Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family docket for Tuesday, March 31st, 2026. The time is now 2 p.m. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this afternoon include Ms. Reyes, Mr. Lopez, Mr. Cordova, Ms. Noriega, Ms. Ramos, Mr. Hernandez, Ms. Rivera, and Ms. Lozano. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online as measured by your login times. Ms. Flores.
Yes, Your Honor. First case in person is Attorney Marcel Knotson, page 1, number 1.
Tanya Elizabeth San Miguel versus Alberto Pina, cause number 2011 CVG 2217C3. Good afternoon, Mr. Knotson.
Good afternoon, Judge.
Court marks you present in person. Mr. Estorgio Perez, are you present?
No, Judge,
Give me 1 second. Court marks Mr. Perez not present. Tanya
Honor,
Elizabeth San Miguel, are you present? Court, one more time. Tanya Elizabeth San Miguel, are you present? Court marks Ms. San Miguel not present. Are you Alberto Pina? Let's turn on his microphone, please.
Yes, Your Honor.
Welcome to court, Mr. Pina. Court marks you present in person. The person to your left is your lawyer. Mr. Gonzalez, are you making an appearance on behalf of the Attorney General's office?
I am, Your Honor.
Mr. Gonzalez, welcome to court. The court marks you present. You're participating by video conference on behalf of the Attorney General's office. Mr. Knotson, go ahead.
yes, I had provided an offer to Mr. Peña late last week. He said he had not had a chance to talk to her about it, but he would do so after the Easter break next week. And asked, we did a Rule 11 agreement subject to the court's approval to get another pretrial within 3 weeks at the court's convenience, and we should hopefully have an agreed order by that time.
An agreed order resolving all matters in this case?
Yes. Thank you, Your Honor.
Let me ask, I don't know the answer. I guess let me look at the calendar, but let me ask our court coordinator, do we have any pretrial hearings before April the 28th?
April 22nd at 9 a.m., Your Honor.
All right, April 22nd at 9 a.m. Mr. Gonzalez, anything to put on the record or request?
Not at this time, Your Honor. Thank you.
Mr. Pina, there's your lawyer has been communicating with Ms. Almiguel's lawyer, and they seem to think that they can work a lot of these things out between now and April the 22nd. It's very important that between now and then you keep in contact with your lawyer. Do you have any questions for me at this time?
No, Your Honor.
All right. Anything else on this case, Mr. Knotson?
Nothing, Judge. Thank you so much.
Any other cases for Mr. Knotson?
Your Honor, that'll be page 2, number 4.
This is Alma Alicia Salas Vasquez versus Anthony Bouvier, cause number 2018 FLI 1884C3. Court marks Mr. Knotson present in person. Speak into the microphone and tell the court, are you Anthony Bouvier?
Yes, I am, Your Honor.
Welcome to court, Mr. Bouvier. The court marks you present in person. Who's the person on your left?
My son.
How old is your son?
He's 11 years old. His name is Jaden Angelo Bouvier.
Is there a reason why you brought him up front?
Well, I told him to bring him. He's 11 and a half, Judge, but he can sit in until it's necessary.
Let me ask this before I get any other announcements. Mr. Knotson, will this be a contested hearing?
Basically, Melissa's raising her hand. Is she?
I just need to know whether to excuse this child or not. Do you believe it's contested? Whatever your
Uh,
belief is. I'm not fishing.
Yeah, she was pro se. The judge extended the hearing to give her a chance to find a lawyer. I'm not sure if she has or not.
So you don't know if this is contested. Ms. Aldana, are you making an appearance?
Yes, Your Honor, thank you. I have just been retained by Miss Alma Salas, so I am requesting a reset to try to get familiar with the case and even try to confer with Mr. Knotson.
That's fine, Judge. I have no opposition to that. We just asked that it, if she asking for 2 weeks, we just extend the order. Or does she want 3 weeks or that April?
Are
22nd date?
are you Alma Alicia Salas Vasquez?
Yeah,
Welcome to court, Ms. Vasquez, the court martial president in person. You have spoken to and have chosen to hire Ms. Saldana, who is present by video conference, as you can see her on this device.
yes, I just hired her yesterday.
Mr. Gonzalez, are you making an appearance on this case?
Yes, Your Honor.
Welcome to court, the court martial president, also by video conference on behalf of the Attorney General's office. Policy of the court, lawyer's first appearance, but this would now be the third setting, so this is it. Ms. Flores, give us another temporary order setting, please.
That'll be April, I'm sorry. April the 16th at 2 p.m.
Your Honor,
Yes.
if I may, before we're dismissed on this case, the mother is just concerned about the child taking his medication. She just wants to confirm that he is taking it since the father has not picked up the medication. Also, the other concern is that the child is being dropped off at school too early and he's in a self-contained unit, so he should not be alone for that amount of time that when he drops off the child.
All right, so Ms. Salas Vasquez, Mr. Bouvier, you're not excused, you're not to leave. Ms. Alania, call Mr. Knotson and talk about these things before, you're asking for a contested hearing, but you're also asking for a reset. So talk to each other because I don't want to put Ms. Salas Vasquez or Mr. Bouvier in a bad position where people are asking questions and it could get them in trouble. So before you do that, it's very likely, if I were a parent in this situation, that I would want my child to be taking whatever medications they should. So talk to each other and reapproach. No one is excused. Stand by.
Thank you, Judge. I'll call her right now.
Next case, Your Honor, is Attorney Olivero Canales, page 4, number 10.
Jesus Tomas Chong versus Miriam Lugo Chong, cause number 2025 FLA 1522C3. Court marks Mr. Canales present in person. Good afternoon, Mr. Canales.
Good afternoon, Judge.
Jesus Chong, Miriam Chong, any party present?
I don't think so, Your Honor. I filed a motion for continuance. I spoke to both parties. Ms. Chung is pro se. They're trying to reconcile, Your Honor, and they asked me if I could ask you if they could have a little bit more time.
Absolutely. For purposes of attempted reconciliation, the request is granted. Is this a new case filing?
It's 2026, I believe, Your Honor.
Yeah, I think I'm going to re-add you to the list because I think the request had been to come off, but since you're still
Okay.
making appearances on the family law case, we still need many more attorney ad litem, so we'll keep you on the
Okay.
list.
That's fine. Your Honor.
All right, Ms. Flores, give us a setting for another trial of merit. Oh, how much time
About
do you
60
think?
days is what they're asking for, Your Honor.
I think that's good. Give us a setting in 2 months, please.
June 4th at 2 p.m.
All right. Any other cases for Mr. Canales?
Yes, Your Honor.
Yes, Your Honor. He is on page 7, number 19.
This is Jose Valdenegro III versus Yaritza Villarreal Peña, cause number 2026 FLA 7C3. Court marks Mr. Canales present in person. Mr. Raul Gonzalez present by video conference on behalf of the Attorney General's office. Jose Luis Castillo, are you present? Court marks Mr. Castillo not present. Speak into the microphone and tell the court, are you Yaritza Villarreal Peña?
Yes, I am, Your Honor.
Court marks you present in person. Are you Jose Valdenegro III?
Yes, I am.
Welcome to court, Mr. Montenegro. The court marks you present by video conference. Mr. Canales.
Your Honor, I spoke to Mr. Castillo this morning. He filed a motion for continuance by agreement. I think he had a mediation all afternoon today. And also, we still need to exchange some more information. So we're asking for about a 30-day reset, Your Honor.
Court finds that additional discovery requires additional time. Give us, I'm sorry, the request was for 30 or 60?
30, Your Honor.
The written request
Oh, I'm
is
sorry.
60. Give us a setting in 45 to 60, please.
June 4th at 2 p.m.
All right, Mr. Aldenegro, do you have any questions for the court?
No, not at the moment.
Ms. Peña, do you have any questions for the court?
No, I do not.
Anything for the record, Mr. Gonzalez?
No, Your Honor.
Anything else, Mr. Canales?
No, Your Honor.
Any other cases for Mr. Canales?
That is all for Mr.
It's
Canales.
good to see you, counsel. Have a great day.
May I be excused?
Yes, sir.
Next case is attorney George Algilt. Mr. Goldsmith is here for Mr. Algilt on page 7, number 20.
That is Anthony Composto versus Chantal Jasmine Composto, cause number 2026 FLA 31C3. Court marks Mr. Goldsmith present in person. Mr. Garcia present by video conference. Good afternoon to both.
Good afternoon, Your Honor.
Anthony Composto, Chantal Composto, are you present? Court marks neither party present. Folks, there's a motion. Oh, are you Chantal Composto? Unmute your device, please.
Hello, Chantal Composto is present.
Welcome to court, Ms. Composto. The court marks you present by video conference. One more time, Anthony Composto, are you present? Court finds Mr. Composto not present. I think there was a motion for continuance that the court denied because the motion came in after, excuse me, the vacation letter came in after the notice of setting. But more importantly, this is the only reason we're set for today is for the appointment of that item. So all I need to hear is whether there's an agreement or a disagreement as to the appointment. If there's an agreement, do you have a person in mind, or would you like me to pick the next person off the list?
Your Honor, I have not had a chance to confer with Mr. Garcia. However, my recommendation in this matter would be to appoint Julio Garcia as an item.
Thoughts,
That
comments,
would be-
response?
That would be fine, Your Honor.
I called this case at 2:12. It is now 2:13, and this is why I denied the continuance. In 1 minute, it got resolved. Very good. Court will appoint Mr. Julio Garcia by agreement. And that resolves that. We'll come back for a final hearing on trial on the merits on April the 2nd at 9. He's going to need more time. We'll call it then. Anything else on this case, Mr. Goldsmith?
No, Your Honor, I believe that completes my business before the court.
Mr. Garcia, anything else?
Not on this case, Your Honor.
Anything, any questions, Ms. Composto?
Well, I wasn't in agreement for the ad litem, but I guess the decision has been made.
Yeah, your time to have spoken up would have been at the time that your attorney didn't object. But
Oh.
he spoke for you. All right, keep in contact with your lawyer and keep in contact, make yourself available to Mr. Garcia. Mr. Juan Garcia, Mr. Goldsmith, good to see you both.
Good to see
Have a
you.
good day.
Your Honor,
Thank you, Your Honor.
Yes,
will they set the final hearing? Are they gonna need more time?
well, you know what? I'm gonna call this on April the 2nd, and it's very likely that Mr. Garcia is gonna need more time in any event. Any objection to moving that date now, Mr. Garcia?
No, Your Honor.
Mr. Goldsmith? Give us another setting in 45 days or so.
That would be May 19th at 2 p.m.
All right, I'll see you then. I wish all persons well. Have a good day.
Thank you, Your Honor.
Next case is Attorney Oscar Vela, page 2, number 5.
Noemi Mireles versus Luis Castillo, cause number 2023 FLC 1507C3. Court marks Mr. Vela present in person. Mr. Raul Gonzalez present by video conference. He's here on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Luis Castillo?
Yes, sir.
Welcome to court, Mr. Castillo. The court marks you present in person. Do you have a lawyer? Will you be going forward today without a lawyer?
Yes, sir.
Court marks you self-represented. Noemi Mireles, are you present?
She should be on Zoom, Judge.
I believe she's in the waiting.
Uh, One more time, Noemi Mireles, are you present? Is there a device identified with that name?
Yes, Your Honor.
Ms. Mireles, I'm going to ask that you stop moving and unmute your device, please. Are you Noemi Mireles?
Yes, I'm Noemi Mireles.
Welcome to court, Ms. Mireles.
Let me
Court
just go
marks
to
you
the room. Excuse me?
present by video conference. Your lawyer is present in person. Mr. Vela, go ahead.
Sorry, Judge, we have 5 children
Right.
at matter in this case.
I understand.
Judge, this was a case that was originally filed by the Attorney General's office. It was a motion to enforce and to modify and clarify a prior order. We were here back in January. The court ordered Mr. Castillo to produce some records. Unfortunately, I did not receive those records. I conferred with Mr. Castillo just this afternoon. He tells me that he emailed them to the AG's office. So I had filed a motion to enforce on myself. And so I'm not sure if the AG's office is ready to go forward, but I would respectfully request a continuance to allow us an opportunity to review the information that was sent to the Attorney General's office for child support purposes.
Many questions. First question to the Attorney General's office. Mr. Gonzalez, do you have any method of ascertaining whether in fact Mr. Castillo sent you or your office any documentation?
Your Honor, I would need a little bit of time to ask my team to make sure that nothing was sent or something was sent.
So you don't know the answer, Mr. Castillo. Mr. Vela tells the court that you told him that you sent the Attorney General's office some documentation via email.
Yes, sir. I have them there. I have the copy as well.
You have copies of the documentation? Into the microphone so that you're on the record.
Yes, the email where I sent it and the documents.
How many documents did you transmit?
Just one. It was on February 8th, 2026.
You said just one document?
Yes, it's 1099.
Is this the document that you were requesting, Mr. Vela?
Yeah. You ordered multiple documents to be submitted, Judge. I was under the impression that nothing had been tendered, but he did say that he sent the 1099. Let me tell you exactly what the court ordered. The court ordered him to produce income tax return for the previous 2 years. If no return had been filed, then the W-2 1099 Schedule K for each of the years. You ordered him to produce all payroll checks and paychecks for 3 months before the date of the order, which was January 28th. And you ordered him to produce all policies describing any medical benefits. And so you ordered that would be produced by February the 13th. I had not received any of the information, so I was going to ask for a continuance. But if Mr. Castillo can produce that information pursuant to the court's order, so we could go forward.
So what you sent, if I don't know that it is, but if all of this is true, Mr. Castillo, and you didn't send tax returns, but you sent a 1099, have you filed your 2025 income tax returns?
No, not yet.
And that's why you sent the 1099. Now, you sent the 1099. Did you also have the opportunity to send over the payroll information as ordered?
No, I don't, because I get paid cash. No checks or nothing, just cash.
Hmm. And what about medical policy benefits?
I have I'm better.
Say that again.
I'm better. Insurance.
Is there documentation that you can
I have it on the
copy?
phone to add that, but I can print it out if you want to.
Well, it's not that I want to or not. I just want to make sure that the court orders are followed and whatever is easiest for you, you can do that. So you can either print all those things out and email it to Mr. Vela. If you can't print out perhaps a screenshot of that same exact information without any changes or modifications and send that information. My thing here isn't what I want. I just, the thing that I want is to make the best decision in this case. And the best decision is going to be based on all the important information. And that's going to include your 1099s, your payroll information, your medical benefits. Without knowing anything else, it would seem to the court that if 2025 returns are not filed yet, and we're only talking about 1099, I would presume then, without knowing anything else, and I'll get a word in from everybody, then perhaps 2024 information would also be important and relevant. Unless the modification happened after those income taxes were reviewed, Mr. Vela.
Judge, if I recall correctly, the AG's office had filed a motion to modify because there was no step down in the child support, because there was 5 children involved. And so then they requested their standard request for production, which included typical modification requests. So this is a 2024 order. It's not a really old order. And so there might be a basis for modification as they had requested, but we need the information to determine that. And so then after the AG's filed the modification, Mr. Castillo filed a modification, but his lawyer withdrew. And so now we're here on that original modification with an order to enter judgment for arrears.
May I hear from Mr. Gonzalez, please?
Yes, Your Honor. I haven't received a message from my team regarding the email from Mr. Castillo. That said, we did file the financial activity report for this case earlier today regarding the arrears balance.
All right. So you heard the affirmations here in court, Mr. Gonzalez, with the 1099 and medical benefits. Would that put the Attorney General's office in a good position to make a final request to the court at final hearing?
We would probably ask for a little bit more information, Your Honor, just so we are aware of his current salary and regarding the medical support, that everything is fine and how it's being paid. We would want that information from Mr. Castillo, Your Honor.
So you heard Mr. Castillo and what he told the court about how he gets paid. Given that, what information can he provide to you in your office that would help you make that assessment?
We would have to talk to him, Your Honor. I assume that we could probably look up his tax returns from our end, but if payments, I mean, if any of that money, any of those salaries are cash, it's going to be
to
kind
the
of different.
court's point, to the court's point, as stated earlier, the 2024 taxes just became irrelevant. All right. Any objection to the court making that order in the interest of justice and in the best interest of these children, Mr. Vela?
No.
Any objection, Mr. Castillo?
They're all good then.
Any objection? All right. Any objection, Mr. Gonzalez?
No.
All right. How much time, and give yourself a good amount of time so that so look,
Yeah, I know.
they're not going to want to come back in here and say that you're not in compliance and order you to pay a fine or go to jail. Nobody wants that to happen, really, but they could. So you tell me how much time would be reasonable for you to compile your 1099s, your 2024 income tax returns, and your medical benefits, and send those both to the Attorney General's office and to Mr. Vela.
I will need to get with my previous employer from 2024, which is the President Drilling. I need to call him, call HR and see what I can do. I'm not really sure, but I'll try to get it.
Would they have your 2024 income tax returns?
Not the returns, the W-2, yeah. They haven't filed it.
Yeah.
You haven't filed your 2024 income tax. Oh, I see the issue. Well, how much time would that be? What would be reasonable for you to communicate with them and for them to give you that information?
I still got the number. I can find it today, and I don't know how much time they will take to send that to me.
This is what I don't want. I don't want to give you a week and you need 2 weeks. I don't want to give you 2 weeks when you need 3 weeks. So you tell me before, I don't want to get you in trouble. So you tell me how much time you think you need, and I'll give you a little bit more, but be realistic.
I don't know if you want to give me like 5 minutes right now, so I can tell my brother like he still works there. Like maybe I can do something real quick right now.
I mean, the sooner the better, but I'm not asking that you do it today.
No, just to make sure like how much.
Self-rep, please get closer to the mic.
Talking to the microphone.
Oh, just to make sure like how much does HR take to send the information?
All right, let me place this case on pause.
Could we set a 30-day deadline? I think that's more than enough. The tax returns are due by April 15th. We're already on March 31st. That should give him sufficient time. I mean, if he needs more time to get the information, then he can tell me. Because he's representing himself, he's
Sure.
told me that he'll call me and that we'll confer. And I'm willing to work with him on getting the information.
Any objection to 30 days, Mr. Castillo?
No, sir.
All right.
Judge, one final thing, Judge. I had filed a motion to modify to lift the geographic restriction. I've conferred with Mr. Castillo about whether he would oppose lifting the geographic restriction. He told me in the hallway that he does not oppose my request as long as we make an agreement with regards to drop off and pickup times. And I told him that I would confer with my client about that. I just wanted you to know that, Judge.
All right. I appreciate it all. All right. So those things, the 1099s and any and all payroll information regarding 2025 and 2024 earnings and the medical benefits are due in 30 days. That is on April the 30th. So that is your deadline to turn all these things in. Ms. Flores, does the court have Mr. Castillo's email address?
Yes, Your Honor.
All right, so just be on the lookout at your email. That's where I'm going to send you. If the court needs to send you any information, notices, orders, it'll go there. Same thing for Mr. Vela or the Attorney General's office. Mr. Castillo, do you have any questions for the court?
No, sir, not right now.
Let me reschedule this final hearing for 45 days, 45 to 60.
June 4th at 2 p.m.
Ms. Mireles, do you have any questions for the court? Unmute your device, please.
Sorry, I do apologize for the noise. And no, I don't have any questions.
No worries. I appreciate that. Thank you, Ms. Mireles. Mr. Gonzalez, anything else to add on the record?
No, Your Honor. Thank you.
Mr. Vela?
No, Judge.
Any other cases for Mr. Vela?
That is all for Mr. Vela.
Good to see you, counsel. Have a great day.
Thank you, Judge. Have a great day.
Thank you.
Next case is Attorney Agustin Ferreira, page 3, number 8.
Adrian Garza versus Karim Verástegui, cause number 2025 FLA 1412C3. Court marks Mr. Ferreira present in person. Attorneys Guillermo del Barrio, Javier Montemayor, are you present? Court marks no other counsel present. Are you Karim Verástegui?
Yes, Your Honor.
Court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person. Adrian Garza, are you present? Court marks Mr. Garza not present. Mr. Ferreira, this is the third setting. What is the announcement?
Yeah, Your Honor, last time we were here, the court appointed Mr. Montemayor, now Judge Montemayor, as an ad litem. He still hasn't finalized his report. We've been conferring, Mr. Del Barrio and I, about visitation. The parties have an agreement. I do have a Rule 11 signed by my client and I. I'm waiting for Mr. Del Barrio to make an appearance. I think he was in another court. As soon as we have that signed, we can file it with the court.
I'm sorry, file what with the court?
The Rule 11 on visitation.
And that should resolve any pending matters?
It'd be pending until we get Mr. Montemayor's report or recommendations. it's
Hmm.
just been difficult to work on. He's really busy I think the court gave us last time 30 days for him to finalize that.
Has he commenced work?
He's interviewed my client,
Mm.
I think he's missing one of the children, but he has.
Okay, give me 2 dates, Ms. Flores. Give me a trial on the merits date in late May or anytime in June.
June 4th at 2 p.m.
Give me a dismissal date in July.
July 9 at 2 p.m.
All right. Anything else on this case, Mr. Ferreira?
No, Your Honor.
I think before I release you, just between now and June, just advise your client on appropriate attire in court, and we'll see you in June. Good luck.
Thank you, Your Honor.
Have a good day, Ms. Verástegui.
I confirm with
Thank you,
Ms.
sir.
Saldana.
All right, give me 1 second, Ms. Flores.
Yes, our next case is Attorney Maddox. Mr. Maddox is in for Attorney Adriana Maddox on page 4, number 11.
This is Monica White, Brian White, cause number 2025 FLA 1592C3. Court marks Mr. Edward Maddox present in person on behalf of respondent. Madeline Escoto, are you present?
I am present, Judge. Good afternoon.
Good afternoon, Court Martial President participating by video conference. Monica White, Brian White, are you present?
No parties present, Judge. We agreed on a motion for continuance. Ms. Maddox has been ill, Judge, and we just needed additional time since she needs to turn in some documents to me.
That's correct, Your Honor. There's an agreed motion for continuance that was filed this morning, and the parties need to exchange some financial documents and see if they can confer further to work this out and clear it check it off your list.
I appreciate that.
And it's always nice to see Mr. Maddox, Judge.
Just writing in additional language on court finding. The court finds that document exchange requires additional time. Now, before I set it for final pretrial, Mr. Scotto, since you're one of the two lead attorneys, what are the odds that this case will require a final pretrial?
We had agreed already, Judge, as soon as we exchange this information, we would exchange settlement offers. And if we can't agree, I'm assuming she'll agree to mediation, Judge. If you can give us 30 days and we should be done by then.
For final?
For final.
And forego a final pretrial?
Yes, I don't think that's necessary.
Any objection, Mr. Maddox?
No, Your Honor.
Without objection, give us a final setting, please.
May 5th at 2 p.m.
All right. Any other cases for Ms. Maddox or Mr. Maddox?
Yes, Your Honor. That will be on page 6, number 17.
Is Ivan Dominguez versus Abigail Alonso, cause number 2025 FLC 602C3. Court marks Mrs. Cotto present and participating by video conference. Mr. Edward Maddox present in person. Ms. Leticia Garcia also present and participating by video conference. Ivan Dominguez, Abigail Alonso, are you present? Court finds neither party present. Mr. Maddox, Mrs. Cotto, go ahead.
Yes,
This
Your Honor.
case-
Oh, there's been a proposed final order that Mrs. Scotto filed this morning. That is
That is
agreed.
correct, Judge.
Anything for the court to consider, Ms. Garcia?
Nothing, Your Honor.
Anything to apprise the court regarding fees?
No, Judge.
All right. The court has received, reviewed, and considered an agreed order in suit affecting the parent-child relationship. It is in due form, signed by all persons, all counsel, including the guardian ad litem. It is well taken. The court finds that these changes are in the child's best interest. The court has signed it and is tendering the original signed order to the clerk's office. That concludes this case.
Correct, Judge.
Thank you all. Any other cases for Mr. or Mrs. Maddox?
Yes, I believe Mr. Maddox is always standing in for Attorney Julia Rubio on page 1, number 2.
Yes, Your Honor.
This is Daniel Garcia versus Ana Karen Manrique, cause number 2012 CVL 325C3. Court marks Mr. Edward Maddox present in person on behalf of petitioner, Ms. Cigarroa, present and participating by video conference on behalf of respondent, Ms. Leticia Garcia, present by video conference. She's the court's appointed attorney ad litem, and Mr. Raul Gonzalez, present by video conference on behalf of the Attorney General's office. Are you Ana Karen Manrique?
Yes, I am, Your Honor.
Welcome to court, Ms. Manrique. The court marks you present. You're participating by video conference. As you can see and hear from your device, so is your lawyer. Daniel Garcia, are you present? Court finds Mr. Garcia not present. Mr. Maddox, Ms. Cigarroa.
Yes, Your Honor. I'm sorry, Mr. Maddox.
I understand that the parties have filed a Rule 11 agreement because we need a little more time for an ad litem recommendation on the case.
And Your Honor, if I could add to that, this is the second time the court hears that because Ms. Garcia has been working diligently, not just with my client, but also with me. And I'm assuming she's been doing the same thing with Dad and with the children. So I can tell the court that she has been working very diligently.
Well noted and well taken. Ms. Garcia, how much time would be reasonable and necessary to, and then I'm going to have to add in some time because once you formulate your thoughts, you're going to share those with counsel. Counsel has to share those with their clients. So how much time to complete your work?
Judge, I'm assuming 30 days, Ms. Cigarroa. Do you think that's pretty much about right? We're in a trial period, Your Honor, of a totally different visitation setup that we have been undergoing for the past about 2.5 months. So there are a few issues that we just need to try to hash out. Do you think 30 days, Ms. Cigarroa?
Yes. And I think the sooner we can resolve it, the better, because it's been hard for the kids and for Mom, and I'm assuming Dad too.
We could do less. We could do 2 weeks.
It would really be up to how you feel, Ms. Garcia.
We could do 2 weeks, Judge. I've spoken to all of them a few times, and so I was really Ms. Cigarroa was out of state, and so I wanted to touch base with her.
Well, I
I was out of state yesterday. Yesterday, I was out of state.
Well, I know Mr. Maddox is graciously appearing for Ms. Rubio. I would prefer at this juncture, unless somebody has an objection, to schedule this after April 16th, which is when Ms. Rubio's notice finalizes for her leave. So, Ms. Flores, give us a setting in 30 to 45, please.
That will be May the 19th at 2 p.m.
Now, and that gives Ms. Garcia some time to finalize, some time for counsel then to advise their clients to digest, Ms. Rubio to come back to full speed before then. And hopefully Ms. Cigarroa, Ms. Garcia, and Ms. Rubio will have some time to talk before the setting and see what headway can be made. And all right, anything else on this case, Mr. Maddox? Final setting, final hearing, May the 19th at 2. Anything else, Ms. Cigarroa?
No, sir.
Ms. Garcia?
No, Judge.
Mr. Gonzalez?
No, Your Honor.
Do you have any questions for the court, Ms. Manrique?
Not at this time.
All right, between now and May the 19th, keep in contact with your lawyer and continue to make yourself available to Ms. Garcia. I wish you and Mr. Garcia well. Have a good day.
Thank you, Judge.
Any other cases for Mr. Maddox or Miss Maddox?
That is all.
Miss Figueroa.
On page.
Good to see you, Miss Figueroa. Have a great
Thank
day.
you, Judge.
On page 8 on Chong,
Page 8, number 21.
I think we just retained.
This is Jorge Chong versus Alejandra Chong, cause number 2026 FLA 284C3. Court marks Mr. Maddox present in person, Mr. Chu also present. He's present by video conference. I'm going to ask that you unmute your device and tell the court, are you Jorge Chong?
Buenas tardes, señoría.
Are you Jorge Chong?
Sí.
Welcome to court. The court marks you present by video conference.
Por medio de videoconferencia.
As you can see and hear from your device, your lawyer is present in also by video conference.
Como puede ver usted, su abogado también está presente por medio de videoconferencia.
Alejandra Chong, are you present?
Alejandro Chong está presente.
Court marks Ms. Chong not present.
El juzgado marca a la señora Chong no está presente.
Mr. Maddox, Mr. Chu.
Yes, Your Honor. We filed a Rule 11 earlier today for the next available setting because we were just hired and Mrs. Maddox needed just a little bit of time.
Hemos sometido una regla número 11 porque nos acaban de contratar a nosotros y estamos solicitando más tiempo
So work out temporary orders and see if we need to file a counter petition.
para trabajar en órdenes temporales.
That is correct, Judge.
Es correcto, su señoría.
This is the reason why I prefer motions for continuance
Esa es la razón por la que prefiero las notificaciones para una continuación
with orders.
por medio de órdenes.
I've written in language into the Rule 11 that the court finds that respondent's counsel was recently retained
He puesto una notificación en el documento que dice que el abogado ha sido recientemente contratado
and requires additional time in the interest of justice.
y requiere tiempo adicional por el interés de la justicia.
I'm tendering that signed copy to the clerk's office.
Entregando esta copia a la secretaria del fondo.
Give us a temporary order setting, Ms. Flores.
Denos una fecha para órdenes temporales.
April 22nd at 9 a.m.
Abril 22 a las 9 de la mañana.
Anything else on this case, Mr. Chu?
We have nothing further, Judge. Thank you.
No tenemos nada más. señor.
Mr. Maddox?
Nothing further, Judge.
Señor Maddox, nada más.
Mr. Chong, keep in contact with your lawyer and we'll see you on April the 22nd at 9.
Señor Chong, manténgase en contacto con su abogado y lo vemos en abril 22 a las 9 de la mañana.
Do you have any questions for
Gracias.
the court?
Thank you. ¿Tiene alguna pregunta?
No.
No.
Good luck to you and Ms. Chong. You're
Buenas tardes
excused.
a usted y a la señora Chong, ya se puede retirar.
Any other cases for Mr. Maddox?
I hope not.
That is all.
Have a great day. Good to see you. Yes, sir.
Next case, Attorney Philip Del Rio, page 3, number 7.
This is Raylen Hernandez versus Martin Ramiro Maldonado III, cause number 2024 FLI 1859C3. Court marks Mr. Del Rio present in person. Oscar Peña, are you present?
Yes, Your Honor, I'm here.
Welcome to court, Mr. Peña. Court marks you present by video conference. Court marks Mr. Raul Gonzalez present by video conference on behalf of the Attorney General's office. Are you Raylen Hernandez?
Yes, Your Honor.
Welcome to court, Ms. Hernandez. The court marks you present in person. As you can see and hear from this device, your lawyer is present by video conference. Are you Martin Ramiro Maldonado III?
Yes, Your Honor.
Welcome to court, Mr. Maldonado. The court marks you present in person. The person to your left is your lawyer, Mr. Peña. Mr. Del Rio, go ahead.
Your Honor, we're here on trial of merits on a motion to modify, and I believe we're gonna need a hearing, Your Honor.
Mr. Peña?
That's fine, Your Honor. I need to, I know that we disagreed on the question of travel burden, but I would inquire whether the disagreement is more than that. So I'll go ahead and talk to Mr. Del Rio. You want to go ahead and set us up for a contested hearing?
So without knowing anything else, this becomes the second contested matter on the court's docket. But before I release momentarily Mr. Del Rio, what do you believe at this juncture are the contested matters?
The contested matters, Your Honor, would be the frequency of the visits for father and the burden of the expense to bring the children from where they're living now to those visits with father, and who should bear that expense.
All right.
And for a method of, or possibly consider factoring in a reduction in child support as an offset to those expenses.
Mr. Peña, you heard Mr. Del Rio say that frequency of visits with father and expenses and possible offsets for those visits. Do you know of, or can you think of any other contested issues at this juncture?
No, Your Honor.
Let me ask you some factual backgrounds before I release you to confer. Mr. Del Rio, how many children before the court?
2, Your Honor.
Ages?
3 and 5? 4 and 2, I'm sorry.
4 and 2, and the genders?
Male and female.
The 4-year-old is?
Male.
2-year-old?
Female.
And you said, or I heard here, that visitation, travel, and expenses are an issue. What county does your client live in?
Webb County, Your Honor.
What county does Ms. Hernandez live in?
I don't know the name of the county. She lives in Washington State.
It is King County.
Washington State. All right. You heard all of these things, Mr. Peña. Any disagreement with any of these factual background?
No, Your Honor.
All right. I got a good handle for where we're going to pick up. All right, Mr. Peña, Mr. Del Rio, good luck as you confer. Mr. Maldonado, Ms. Hernandez, keep in contact with your lawyers. I'll call your case momentarily.
Thank you, Your Honor.
Next case, Attorney Julio Garcia, page 4, number 9.
It's Jessica Cruz Salazar versus Aaron Salazar, cause number 2025 FLA 1430C3. Court marks Mr. Garcia present in person, Ms. Escoto present by video conference. Good afternoon to both.
Good afternoon, Judge.
Jessica Cruz Salazar, Aaron Salazar, are you present? Court marks neither party present. Counsel, go ahead.
Judge, I think Mr. Garcia and I probably deserve a medal on this one. We submitted the agreed proposal to the court. The court has signed it, and so we're ahead of schedule, and we just need an entry date.
Wow. Oh, well, very well taken and appreciated.
So the record reflects, Judge, it was all me, but I would have Madeline to prepare the paperwork. So.
And for the record, the reason, if it's not obvious for the record, we're just at final pretrial, and counsel has resolved all. I guess if you're asking for entry, you have that final hearing on April the 28th. Instead of converting it, I can just add on. So final hearing and entry.
Sure, Judge.
That's fine, Judge. April the 28th?
April the 28th at 2 is your TOM, but we'll add entry of judgment on that day.
I'll get it to him by next week when I return from my vacation, Judge.
Thank you, ma'am.
So as best I can tell, this was not straightforward, complex, and contested, and you all got there. I appreciate you and your efforts, Mrs. Cota and Mr. Garcia. Thank you both.
Thank you, Judge. My big excuse, Your Honor.
Good to see you.
Thank you, Judge.
Next case, Attorney Silverio Martinez, page 3, number 6.
This is Melissa Monette Cortez versus Brian Alexander Hale, cause number 2024 FLI 785C3. Court marks Mr. Martinez present in person. Good afternoon, Mr. Martinez.
Good afternoon, Your Honor.
Court marks Mr. Garcia present by video conference. Good afternoon, Mr. Garcia.
Good afternoon, Your Honor.
And court marks Mr. Raul Gonzalez present by video conference. Good afternoon once more. Parties, Melissa Cortez, Brian Hale. Any parties present? Are
Here,
you,
Your Honor.
I'm going to ask that you unmute your device and tell the court, are you Melissa Cortez?
Yes, Your Honor.
Welcome to court, Ms. Cortez. The court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is also present by video conference. Once more, Brian Hale, are you present? Court finds
They
Mr.
called-
Hale
He called and he said that he was in.
right here.
There he is.
Are you Brian Hale? I'm going to ask that you unmute your device, please. Are you Brian Hale? You are not connected to audio. Mr. Martinez, is this your client?
Yes, it is.
Court marks Mr. Hale present and participating by video conference. Mr. Garcia, Mr. Martinez, go ahead.
Your Honor, this is a case brought up for the Master's Court. It was filed as an original SAPSR against my client to establish paternity, child support, and custody. Up to probably late last week, we had an agreement. The agreement was termination with an intent to adopt by stepdad. Up until, like I said, about Friday, I was notified that Ms. Cortez had a change of heart and thus would be wanting to proceed as per her original SAPSR petition filed by Mr. Gonzalez at the Attorney General's office. For that reason, immediately I filed the motion for continuance, Your Honor, advising the court that if that's going to be the case, then we need to come back and change our posture altogether. So I was requesting a PTGO so that we may do some discovery. Our position from the beginning has been that she kept it from my client.
What does she keep?
The fact that it was his child. We have evidence that she denied it to him and is now seeking retroactive child support, in which case I believe that becomes extremely pertinent and relevant. We need some discovery as to that, as well as some other issues. We're also going to be seeking attorney fees, and we had actually filed a counterclaim seeking custody. Because of the fraud, we're alleging that he's been kept from developing a relationship.
I'm sorry, the last thing you said was that you're going to do what now?
I wanted a PTGO. We filed a counterclaim on the original SAPSR, asking for primary conservatorship.
So you have you have two competing requests. You have your initial request is to terminate your client's rights.
We, after filing a counterclaim for primary conservatorship, Your Honor, our negotiations, because of the fact that my client has no relationship with the child, went toward termination. That was the agreement up until, like I said, maybe Friday of last week. And so that's why it came as a surprise to me, because there had already been, we were just pending on a notice of intent to adopt.
But your client's live pleadings, and obviously families are changing, they're evolving, they're organic, they're not static. So things change as time goes on. But for purposes of this case, the live pleadings are termination and sole managing conservatorship.
That is correct.
Mr. Garcia? Before I hear from you and Mr. Martinez, the disagreement, do you believe, and I'm going to ask Mr. Garcia the same question right now, do you believe that the non-agreement at this juncture is on the adoption and termination, or only on the adoption, or everything?
I don't know what happened, but apparently it was just termination is no longer, we're not agreeing to it. And I don't think I can ask for it if you're not agreeing to it.
Well, you could, I guess. Court will have to make a determination based on the evidence and testimony. Mr. Garcia, what say you?
On this case, Your Honor, we had been going, confirming Mr. Martinez and I, Your Honor, but my client, as of last week, she said that she does not agree with the termination, that she's objecting to it, and that she would like to proceed on the establishment of Mr. Hale as the father of the child.
Your Honor, if I can speak.
Who is, I don't know who is trying to speak.
Oh, Melissa, the mother.
You are Mr. Garcia's client. Mr. Garcia, would you like your client to speak?
I don't know what she's gonna talk about, Your Honor, but I prefer if she would.
Well, first, Ms. Cortez, please stop moving and bring the video right in front of your face, please.
I'm sorry, Your Honor, it's because I'm breastfeeding my baby.
Please. I have removed the spotlight. Mr. Garcia, what then do you propose that the court do at this juncture?
My client would like to, from what she tells me, proceed on the on the establishment, Your Honor.
Is paternity not established at this juncture, or is it presumed, or why is a termination filed, but paternity hasn't been established?
There was a DNA test, Your Honor, that was done, and it turned out that he is the father. I think it was an establishment that was originally filed because they weren't presumed.
In the biological world, is there a court order that confirmed that study, that test, and adjudicated him the father?
No.
Your Honor, if I may.
Sure.
Your Honor, the Office of the Attorney General filed earlier, I'm not sure if it was yesterday afternoon or earlier today, the paternity test, genetic testing confirming that Mr. Hill is the father of the child.
But to the court's point, so biologically he's the father. The question is there an adjudication that legally determined and ordered that finding?
Not at this time, no.
So the court at this juncture can outright deny the termination because there is nothing establishing. I guess it's moot because it's not ripe, right? If paternity hasn't been established, there are no rights and there's nothing to terminate. You would first have to adjudicate, this court would have to adjudicate Mr. Hale, the father, and then terminate rights. In fact, without an adjudication of parentage, the request for sole managing is moot. Also, it's not ripe either, isn't it?
No, it's not, yeah. And again,
So then, if all of your life pleadings are moot and or not ripe, what life pleading is left?
I think the one from the Attorney General, Your Honor, that they were the ones who initiated the case.
What is that pleading or request, Mr. Gonzalez?
Yes, Your Honor, I believe this was a patty action. So we were going to establish paternity based off the genetic testing, and we were going to establish child support and everything. That was the original case that we had. I believe I have notes from the previous hearing. My understanding that we were going to do today, we were going to go over the termination and we were going to appoint an ad litem on this case. That's what I have. A lot of stuff happened between then, so.
Yeah, so without any final finding, orders, or ruling, I'm just going to make an observation, not a rendition, but the request to terminate and the request for sole managing may be highly relevant in the future, but at this juncture, it's not ripe and moot. So I tell you what, let's do two things so that we can all be on the same page and get on track. I'm going to give you 2 dates. I'm going to give you a final pretrial hearing and a final hearing on the adjudication of paternity on the same date in 45 days, Ms. Flores.
May 19th at 2 p.m.
And then I'm going to give you a final hearing on the termination if it's ripe at that point, but I'm going to schedule it now in June.
June 18th at 9 a.m.
one more time. So final pretrial hearing regarding all issues on this case and also a final hearing on the paternity, May 19th at,
2 p.m.
and then a final hearing on the termination, should it be relevant, pertinent, ripe, and want the Mr. Hale would want to move on June the 18th at 8 a.m.
9 a.m., Your Honor.
I'm sorry, at 9 a.m. Now, Mr. Garcia, Mr. Martinez, the court finds it necessary to appoint an attorney ad litem. I think enough has been said here to cause the court to not know. It'd be very hard to now even believe either party on whether what's in the best interest based on everything that's happened here today. Competing requests and a person not appearing appropriately by video conference. So, Mr. Garcia, Mr. Martinez, the court is going to appoint an attorney ad litem. Any objection to that, Mr. Garcia?
No, Your Honor.
Mr. Martinez?
No, Your Honor.
All right. Who will be filing orders for the court to sign on that?
I can.
All right. The appointment of the unobjected to order on attorney ad litem is due to the court. Honor before.
April 27th at noon by submission.
All right. Any person that would have a conflict with this case that the court should not appoint as an attorney ad litem, Mr. Garcia?
I don't know of any, Your Honor.
And Mr. Martinez?
No, I don't think there is.
All right. I think the court has done everything necessary to get this case on the right track. Anything else on this case, Mr. Garcia?
No, Your Honor.
Mr. Gonzalez?
No, Your Honor.
Mr. Martinez?
I just want to clarify the dates, Your Honor. The May 19th date is for final adjudication of parentage.
And also for final pretrial hearing.
Oh, for final.
So should you need the court to hear anything other than final, you can still do it then, but just make sure you don't exceed that date.
So my concern is if right now my competing request for primary is not ripe and moot, it won't be ripe and it'll still be moot up until that date. Am I correct?
But you're not set for termination, so.
No, but as far as me requesting primary conservatorship, if adjudication has not occurred, then I'm not ready to even assert that. And
Well, I think you know the results of the biologic test. So what we can do is first adjudicate parentage and then move on. So once the court affirms that and makes that finding, then you make whatever request you want.
okay, I guess what I'm trying to get at is we're not going to get to the merits of primary conservatorship on the 19th of May.
Why not?
Well, because I would need discovery, and the ad litem would have to have had enough time to do what he needs to do or she needs to do. We need a lot of stuff before we have a primary conservatorship hearing. I would suggest,
Or you have a primary conservatorship
because
hearing.
that's the best interest analysis that the court's going to have enough information to weigh. And if I haven't even asserted my claims yet, I haven't done any discovery yet, and we haven't really gone forward on any of it. And I understand that biologically it's been confirmed, but not judicially.
Well, that was the court's point, and that's what unraveled the whole thing and got it on track. But if what you're saying is that you're not going to be able to assert your client's ability to engage in discovery because parentage hasn't been adjudicated, I could give you a third date, but that prejudices your client and it's going to extend the deadlines even more. And if he so chooses to exercise possession, it's going to push it out further. And that's okay if you want to make that request, but just know that you're putting your client in a position to not make that request at least 30 to 45 days further out. And I think under this scheduling order, he can make that claim on May the 19th. Not in June or July.
Right.
But
I think, and I believe that my client would tell the court that he's been prejudiced enough, and
But to,
by who or by what?
well, by Ms. Cortez, by lying to him about him not being the father, he hasn't been able to establish that relationship.
And that's why we're here.
Yeah,
Yeah.
and so my concern is, actually, our concern is not really, is it gonna prolong our ability to see the child when there's absolutely no relationship there? I think that it's more
Well,
important.
let me do this to iron that out, because it is a legitimate concern. I'm trying to short circuit, for lack of a better word. But let me ask you this, Mr. Garcia. If we come back on May the 19th, and I can't hold you to it, but just give me your thoughts. We come back on May the 19th. This court listens to evidence and testimony as to what the court should do to adjudicate or not adjudicate parentage to Mr. Hale. If we then proceeded to possession and access, do you believe you would be lodging an objection at that juncture?
There might be an objection, Your Honor, because since there hasn't been contact with the child, my client would probably want to have at least some kind of gradual schedule or something. So I think
Then that was a good call, Mr. Martinez. All right. Give me a final, well, the only thing I can do, final hearing on parent-child relationship on June the 18th, and then a final hearing on termination in July on
July 9 at 2 p.m.
All right, so now you have 3 dates. Final hearing on paternity, May the 19th. Final hearing on parent-child relationship, visitation, possession, and access on June the 18th. And final hearing on termination, July the 9th. Thoughts, comments, questions, or objections, Mr. Garcia?
None, Your Honor.
Mr. Martinez?
I have a concern, and I'll voice it for the court's consideration. If we adjudicate him on the 19th, and thus my pleadings now become ripe, I have less than 30 days to conduct discovery.
Not if you send it before.
Well, yeah, I don't think I can send it because he'd object to the fact that they're not live.
Except that it would be set for final pretrial on May the 19th. I hear it on the same day that the adjudication takes place, and now he has to respond.
Oh, I got it. Okay. But that'll work.
All right, Mr. Gonzalez, anything for the court to consider?
No, sir, not at this time.
Mr. Hale, do you have any questions for the court?
No, sir.
Ms. Cortez, do you have any questions for the court?
No, Your Honor.
All right, Ms. Cortez, Mr. Hale, keep in contact with your lawyers, keep in contact with the attorney ad litem that the court will appoint. I wish you both very well. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Any other cases for Mr. Martinez?
That is all.
All right, I'll be signing that attorney ad litem order as soon as it comes in.
Awesome.
Good to see you, Mr. Martinez. Yes, sir.
Next case, Attorney Guillermo del Barrio, page 6, number 15.
Valentin Palomares versus Sandra Leticia Palomares, cause number 2025 FLB 1582C3. Court marks Mr. Guillermo del Barrio present in person, Ms. Leticia Garcia present by video conference. Good afternoon to both.
Good afternoon, Your Honor.
Good afternoon, Judge.
Valentin Palomares, Sandra Palomares, are you present?
Yes.
Welcome to court, Ms. Palomares. The court marks you present by video conference from the office of your lawyer. Are you Valentin Palomares?
You need to unmute, Mr.
Mr. Palomares, there's an unmute button at the bottom left of your screen. Press that button to start your microphone and tell the court, are you Valentin Palomares? Mr. Del Barrio, is this your client?
Yes, Your Honor, it is.
Court marks your client present and participating by video conference. Second hearing on a trial merits. Mr. Del Barrio, Ms. Garcia.
Your Honor, I believe Ms. Garcia filed an agreed motion for continuance. We are still in the process of exchanging some paperwork. I don't believe I think if we can get about 30 days, Your Honor, I believe it's what she requested in the motion. I think we should hopefully at the end of the day have a hearing on this matter. I mean, an agreement, sorry.
That's correct, Judge.
What are the what is the issue that you're ironing out?
Actually, Judge, we just put numbers together with regards to all of the offsets and credits that Ms. Palomares and Mr. Palomares will be entitled to with regards to property taxes, extra payments of the mortgage after the house is now paid off, but between the time that he left the home and she continued paying it. In fact, we were likewise speaking with a broker recently about this to see what the options are. And together with a couple of estimates that we are obtaining for fixing the plumbing of one of the bathrooms, as well as what was it? The other thing? Well, a couple of items that need to be repaired at the home, Judge.
Your Honor, there's
The
one
AC.
child, but the child emancipates, I believe, at the end of this, at the end of
At
this.
the end of May.
Yes.
So it's a matter of just putting everything together, Judge.
Yikes. So you tell the court, do you want the court to set it before the end of the school year or after?
After is probably
After then, that will work. I think
Yeah.
we can work out the.
That would be nice.
Without
Sure.
objection, and the court has written into the order, the court finds additional contemplation of financials requires additional time. It is well taken. Ms. Flores, give us a setting in sometime in June, please.
June 16th at 2 p.m.
All right, Mr. Palomares, do you have any questions for the court? Court is seeing no. Ms. Palomares, do you have any questions?
No,
All right, keep in contact with your lawyers. I look forward to hearing your case on June the 16th. Good luck to all.
Your Honor, if we
Thank you,
reach,
Judge.
we can submit it as well.
This is a divorce. You can't submit it by agreement, but if you do, just prove up the jurisdictional requirements so that nobody in 20 years can
Yeah,
complain. So
Okay.
affidavit, stipulation of evidence, or whatever you want on
Perfect.
residency.
We'll do.
All right.
Thank
Good
you,
luck
Judge.
to all. Any
Any
other cases,
excuse?
Mr. Del Barrio or Ms. Garcia?
That is all for both attorneys.
Good to see you both.
I had one earlier.
Have a good day, Judge.
Did already, so they advised me. Thank you, Judge. Your Honor, I got a quick question. It's not a case that's set right now. We got a setting for April 22nd, but it's an unopposed non-proton motion. The VIN number was missing on the decree.
If it was filed in the last 24 hours, it's probably waiting on my desk as soon as I get off the bench, and it's agreed to. I'll likely sign off on it.
Okay. Yeah. Well, I think we were actually set on a fiat for the 22nd. So I can contact the court, but Juan Hernandez on the other side. They're trying to sell the vehicle, so that's why I was going to bring it up to the court.
Understood.
If we can contact y'all, maybe
I'll review.
Perfect. I appreciate it.
Thank you, Mr. Del Barrio.
Next case, Your Honor, is Attorney Madeline Escoto, page 5, number 12.
She's online. We have two lawyers still in person. Let's clear up folks in person, and then so whoever was here in the order.
Attorney Marcel Knotson, page 2, number 4.
Alma Alicia Salas Vasquez versus Anthony Bouvier, cause number 2018 FLI 1884C3. Mr. Knotson, is there an agreement in this case?
Yes, I did talk to Miss
Saldana. So
Saldana.
court marks Mr. Knotson present in person, his client present in person. Petitioner Alma Salas Vasquez present in person, and Ms. Saldana present by video conference. Mr. Knotson, Ms. Saldana, go ahead.
And we conferred with regard to the medication. Her client can deliver it to her office. I personally would go pick it up from Miss Saldana's office or send my wife. So we've agreed to that. And also with the child, there's a teacher there when the child gets there until he starts the class. So basically, we've agreed to those points.
Ms. Saldana.
Well, yes, Mr. Knotson will, or his designated person will come in to pick up the medication tomorrow morning at my office. As far as the teacher, I'm gonna look into just to make sure that everything's going well at the school. I'll just get the name from Mr. Knotson and the contact information.
It sounds to the court that it's, I don't want to say so agreed to that it doesn't require written orders. Do you believe any of this require written orders, Mr. Knotson?
I don't think so, but if you think it does, Judge, we can maybe submit something tomorrow, whatever you think, Judge.
I mean, it sounds so straightforward that I can't imagine. I just don't want somebody to run afoul and the medication not be turned over, the teacher not to be in the class or whatever the case is.
We can follow Rule 11 agreement by tomorrow.
Let's do that. Rule 11 is due to the court on or before April the 3rd. April the 3rd by submission. And then we'll come back for a final hearing. Give us that setting, Ms. Flores.
Mr. Honor, that'll, in how much time?
We're coming back on the 16th for temporary orders, so give me a setting in early June.
I'm
June
sorry,
4th. June the 4th at 2 p.m.
Ms.
that's
Alani?
for, I'm sorry, thank you. Is that for what type of setting?
Final hearing.
Thank you. June
Anything
4th.
else on this case, Mr. Knudsen?
No, that's it, Judge. Thank you so much.
Ms.
Yes,
Alani?
Your Honor. I'm sorry, I missed the temporary order hearing date,
That was April the 16th at 2.
16 at 2. Thank you, Your Honor.
Anything else on this case?
That's it, Your Honor.
Ms. Salas Vasquez, do you have any questions for the court?
Yes,
What's your question?
I would like to know if the restriction order is still valid.
Are you talking about a temporary restraining order that orders that everything be peaceful, amicable, and that there be no violence between you and Mr. Bouvier?
I think that it has more restrictions, Your Honor. She's under the understanding that she cannot communicate with the child and that she can't get any information from the child. But again, I've just been retained, but that's what I understood is in the TRO.
Well, what's the answer, Ms. Alania?
That would be Mr. Knudsen because he wrote the TRO.
I think there's communication, there was just a restriction. I guess her daughter was arrested for assaulting the half brother. And
That's right. So there isn't an agreement. We're moving forward with all of these things. The answer is yes. The answer is absolutely yes. Everything continues in place without any changes. The restrictions continue and they're extended without objection and by agreement until April the 16th at 2.
okay, thank you, Judge.
Even though she has an order to stay away?
Though she has, yes, nobody is contesting anything at this juncture. Ms. Alania, unless I missed something, you haven't objected or sought the court to make a finding based on evidence and testimony to anything else. So everything stays as is until April the 16th. Is that not correct?
That's correct because I've just been retained, so I need to be able to get ready for a hearing.
Not your fault. I understand. Ms. Salas Vasquez, so Ms. Alania needs some time to talk to you, to advise you, and to prepare you for your hearing. She's going to be doing all of that and at the same time talking to Mr. Knudsen about what, if any, agreement can be made. Anything that you don't agree with will come back on April the 16th. So the best thing I can tell you is keep in contact with your lawyer. She's going to fill you in. Mr. Bouvier, do you have any questions for the court?
No, Judge.
Mr. Bouvier, Ms. Salas Vasquez, I wish you both all the best.
Thank
Good
you,
luck.
Judge.
Good luck to
Any
all.
excuse?
Yes, sir.
Good seeing you.
Likewise. Any other cases for Ms. Alania?
Yes.
Okay, so, and she's in the queue, Ms. Flores.
Yes, Your Honor. Attorney Philip Del Rio, page 3, number 7.
Mr. Del Rio, just briefly, is there an agreement in this case? All right, it'll continue on the contested docket. Those folks online, Ms. Flores.
Attorney Madeline Escoto, page 5, number 12.
This is Heel versus Stewart, cause number 2025 FLA 1797C3. Court marks Mrs. Cotto present by video conference. Good afternoon.
Good afternoon again, Judge Madeline Escoto for Ms. Heel. None of the parties are present in this case. The court has already signed the agreement disposing of the matter. I just need an entry date for the final decree as well as the affidavits approval.
Are you asking for an orders to or an entry of judgment?
Submission date, Judge.
Right, orders are due on or before?
April 27th at noon by submission.
All right, well taken.
Okay. Next case for Mrs. Cotto, page 6, number 16.
Rogelio Martinez Jr. versus Erika Lynn Martinez, cause number 2025 FLB 1790C3. Court marks Mrs. Cotto, present and participating by video conference. Sergio Lozano, are you present? Court finds Mr. Lozano not present. Rogelio Martinez, Erika Martinez, any parties present? Court finds no parties are present. Mrs. Cotto.
Judge, I filed a verified motion for continuance. I cannot find Mr. Martinez. We've emailed, we've texted, we've called. I'm sorry, we've emailed and called. If the court just gives me some time to see if I can locate him, so I can finalize his inventory. Mr. Lozano was not opposed to the continuance given my quandary or dilemma in being unable to locate Mr. Martinez. So I'm gonna send him a certified letter, Judge.
Well taken for all the reasons stated on the record. Additionally, this is the first setting, so by policy, the court, the request is honored. How much time would be reasonable? You're going to mail something off. How much time would be reasonable and necessary?
30 days, Judge, should be fine.
Give us that setting, Ms. Flores.
May 5th at 2 p.m.
All right, so ordered.
And that's all I have, Judge. May I be excused?
Good to see you. Have a great day.
Happy Easter to you and your staff, Judge.
Thank you. Likewise.
Next case, Attorney Melissa Saldaña, page 5, number 13.
This is Jorge Perez Jr. versus Norma Hernandez Perez. Cause number 2025 FLB 1235C3. Court marks Ms. Saldaña, President participating by video conference. Mr. Garcia, President participating by video conference. Good afternoon to both.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Jorge Perez Jr., Norma Hernandez Perez. Are any parties present? Court finds no parties are present. Counsel, what is the announcement?
We have submitted the final decree signed by the parties and the attorneys. I signed for my client.
That's correct, Your Honor. We have an agreed divorce decree.
Let me ask you, this case was mediated or was not mediated?
No, the parties reached an agreement without a mediator.
At any time has the court heard evidence or testimony as to jurisdiction?
I was trying to remember. I know we submitted a Rule 11 agreement at the previous hearing. I don't recall if it was through the testimony of the clients. I don't recall.
And I think on the court's notes, Your Honor, it was mentioned and I think I'm not too sure, but I think I might have asked my client some questions. I think it was back on February the 12th.
If I may, Your Honor.
Yes.
The parties were sworn in and the court did adopt and approve the agreement back on February 12th.
Does it say anything about jurisdiction? I mean,
Honor.
say that again?
No.
So neither lawyer knows the answer. Let me see if the answer is in the notes. They're silent as to jurisdiction. So I tell you what, the court will adopt and approve the agreement, but I'm going to set for orders due the affidavit for jurisdiction or the stipulation, so that, because it's not going to be Ms. Alania and it's not going to be Mr. Garcia, but some other person reviews this, they can always contest. They could, not that they would win, but they could. And I would rather nobody coming back and saying that we all got this wrong. So orders due on that affidavit of jurisdiction. Orders due on or before?
April 27th at noon by submission.
So as soon as it comes in, I guess it should be Mr. Garcia. Did you file a counter petition, Ms. Aldana?
I'm sure we did, but let me see. Let me check.
Yes, Your Honor, November 3rd,
All right.
2025.
So you did file a counter petition. So either one can file the affidavit for jurisdiction. As soon as that comes in, either or both, and I'll sign off on the final divorce decree. Just get it to the court before April the 27th. And that'll conclude this case. Anything else on this case, Mr. Garcia?
No, Your Honor.
Ms. Aldana?
No, Your Honor.
All right. Any other cases for either counsel?
Yes, Mr. Garcia down the line. Ms. Aldana is on page 7, number 18.
Did you say 18?
Yes, Your Honor.
Rebecca Isabel Cruz versus Humberto Magallanes, cause number 2025 FLE 1326C3. Court marks Ms. Aldana present by video conference. Rodolfo Santos Jr., are you present?
Good afternoon, Judge. Present on behalf of Ms. Rebecca Cruz.
Good afternoon. Court marks you present and participating by video conference as well. And court marks the court's appointed attorney ad litem or guardian ad litem present, also participating by video conference. Good afternoon to all.
Good afternoon, Your Honor.
Good afternoon, Judge.
Are you Rebecca Isabel Cruz?
¿Es usted Rebeca Isabel Cruz?
I am, Your Honor.
Welcome to court, Ms. Cruz. The court marks you present, participating by video conference. Are you,
El juzgado la marca presente y participando por videoconferencia.
are you Humberto Magallanes?
¿Es usted Humberto Magallanes?
Sí.
Yes.
Welcome to court. The court marks you present and participating by video conference.
Bienvenido al juzgado. El juzgado la marca presente participando por videoconferencia.
Ms. Cruz and Mr. Magallanes, your lawyers are also participating by video conference.
Señor Cruz y señor Magallanes, sus abogados están participando por videoconferencia.
Much slower than normal, counsel. Go ahead.
Un poco más.
Your Honor, this is a termination proceeding regarding an 8-year-old child who hasn't had any contact with his child, with his father since, or his biological father, I should say, since the child was 2 years old. We're seeking termination based on grounds of father's failure to support for over a year and for the fact that father voluntarily abandoned. In this lawsuit, father has agreed to
Let me hear your
voluntarily relinquish.
interpretation and don't, let's do no more than 2 sentences at a time. If you need to repeat all of that, it's okay. Do you need that? I'll repeat it again. Okay, go ahead.
Estamos aquí para la terminación de derechos del padre, ya que el menor tiene 8 años y no ha tenido relación con el padre desde que tiene 2 años. Y por eso estamos solicitando la terminación de derechos.
Your Honor, in this case has been confusing. The respondent in this case, Mr. Magallanes, at least 2 junctures has agreed to voluntarily relinquish. And I believe at our last hearing, he indicated that he no longer wanted to go that route and was contesting the termination. I don't know if that's the case today.
Este ha sido un caso complicado. En 2 ocasiones el señor Magallanes ha indicado que quiere renunciar a los derechos, pero la última audiencia nos dijo lo contrario.
Ms. Aldana?
Thank you, Your Honor. The father has not seen the child because the mother since 2020 at least has been denying all visits. Any request father had, any attempt to visit the child, the mother simply denied the visits, destroyed that relationship, and now we're
Translation, please.
El padre no ha tenido relación con el menor porque la madre del 2020 le ha negado todas las visitas después de todas las peticiones que él ha hecho.
So all of these things, Mr. Santos and Ms. Aldana, are good and important factually.
Todas estas cosas, señor Santos y señora Saldaña, son cosas importantes.
But tell me where you're at procedurally and what each of your requests are today.
Pero dígame, ¿en dónde están en su procedimiento y cuáles son las solicitudes de cada uno el día de hoy?
Yes, Your Honor. I have conferred with the ad litem, Mr. Francisco Tamés. He advised that he did speak to, I believe it was mom and to father, and is, I believe, going to request additional time. I do not object to that. I would also agree to request additional time so that I can confer further with Mr. Tamés and my client.
Yo me he comunicado con el abogado Tamés, que es el abogado al aire. Él creo que ya ha hablado con los padres y estamos de acuerdo en que necesitamos más tiempo.
Mr. Santos.
Your Honor, we don't think that's unreasonable. Mr. Tamés was just appointed, I think exactly 1 week ago. Our concern is the urgency with regard to the child, who should be the central focus of the lawsuit. Part of the termination, one reason we're seeking the termination is that the child will be eligible for adoption by the man who's raised him. We want to get that child covered by private health insurance. So if we're going to reset it, Your Honor, we just have to ask that the court place it on a relatively short fuse.
Creo que no tenemos de convicción. El señor Tamés solamente tiene una semana trabajando en el caso. Nuestra única preocupación es la terminación de los derechos porque empieza el tiempo para que sea el menor adoptado por la persona que lo ha creado, ya que lo quieren incluir en el seguro médico privado de él.
What health conditions are pressing and urgent?
¿Qué problema de salud es urgente?
Your Honor, the child, thank God, is relatively healthy, but at any point, we know with children, anything can happen. So the concern is that we want to make sure that the child has good health insurance.
El menor de edad, gracias a Dios, está saludable, pero como usted sabe, con cualquier menor puede suceder una enfermedad y quisiéramos que tuviera el mejor seguro médico privado disponible.
Understood. I was under the wrong impression.
Entendido, he tenido otra impresión.
I just thought that the urgency that you raised for medical insurance purposes, something must have happened relatively recent, even though there's been no contact for 6 years.
Yo pensé que la solicitud de urgencia del seguro médico era porque había estudiado una situación y ya que no he tenido contacto en los últimos 6 años.
Mr. Tamez, what say you?
Yes, Your Honor, correct. I was appointed as a guardian ad litem on March 2nd, 2026. I have met with Ms. Cruz. I met with her on March 18th. And I met with Mr. Magallanes just last week on the 26th. So I have not yet been able to prepare a report. I do need some time to do so. Whatever the court feels is relevant. I do have a vacation letter in mid-May that I believe is already on file, Judge. But I will be out for about 10 days in mid-May. And so, oh, sorry.
Sí, solamente fui asignado a este caso en marzo 2 del 2026. Me comuniqué con la señora Cruz en marzo 18 y con el señor Magallanes la semana pasada, el día 26. Sí quisiera solicitar más tiempo. Tengo una carta de vacaciones en mayo, creo que por 10 días. Si me podría dar una fecha después de eso.
Mr. Tamez, you said May was your letter?
Señor Tamez,
yes, Your Honor, I believe. Yes, Your Honor. I'm not sure the dates. I think it's the 10th through the 22nd inclusive. I think. I'm sorry, I don't have the correct dates. I can notify the court after we get off the.
Creo que la fecha es de mayo 10 al 22. No estoy exactamente las fechas, pero puedo comunicarte a la juzgado.
Ms. Flores, that letter isn't on the court's calendar. Mr. Tamez, double check as well. Just
Okay, yeah. I'll double check. I thought I had already. Sorry. In case I haven't, but yeah, I'll check into it.
So,
Pero no tenemos esa carta todavía. El señor también sí podría verificar para introducir esa carta.
any objection to early to mid-June, Mr. Santos?
¿Alguna objeción
No
para
objection.
junio? No, no hay ninguna objeción.
Ms. Saldana,
Señora
No
Saldana, no hay objeción.
final hearing in June on
June 16th at 2 p.m.
Audiencia final, julio 16 a las 2 p.m.
Ms. Cruz. Do you have any questions for the court?
Señora Cruz, ¿tiene alguna pregunta para el juzgado?
No, Your Honor.
No, pues, señor.
Mr. Magallanes, do you have any questions for the court?
Señor Magallanes.
No, por el
¿Tiene
momento.
No.
All right, Ms. Cruz and Mr. Magallanes, keep in contact with your lawyers
Señora Cruz y señor Magallanes, manténganse en contacto con sus abogados
and make yourself available for Mr. Tamez.
y háganse disponibles para hablar con el señor Tamés.
He doesn't represent Ms. Cruz
Él no representa a la señora Cruz
and he doesn't represent Mr. Magallanes.
y él no representa al señor Magallanes
He's just going to do whatever is in the best interest of this child.
y él va a hacer lo que sale en mejor interés del menor de edad.
All right, I wish you all well. I'll see you in June. Good luck to all.
Thank you, Your Honor.
Okay. Maybe excuse Your Honor, that's all I have before the court today.
It's good to see you all. Have a good
Thank
day.
you, Judge.
Thank you.
Thank you all.
Next case, Attorney Juan Garcia, page 2, number 3.
Maria Elida Moreno versus Antonio Alatorre III, cause number 2012 CVW 2193C3. Court marks Mr. Garcia present by video conference. Mr. Raul Gonzalez present by video conference on behalf of the Attorney General's office. Are you Maria Elida Moreno? Welcome to court, Ms. Moreno. The court marks you present in person. Are you Antonio Alatorre III?
Yes, Your Honor.
Welcome to court, Mr. Alatorre. The court marks you present in person. Ms. Moreno, Mr. Latorre, the court had a very nice conversation earlier today with your son. Mr. Garcia, what is the announcement?
In this case, Your Honor, there were temporary orders from, I think from November of last year where it was modified, I think from standard over to the respondent having, I think, visitation every first, third, and fifth Friday, starting at 8 p.m. and ending on Saturday at 5 p.m. I've been speaking to my client and he would like, or he would like to change it back for the respondent to have standard visitation.
More visitation, not less.
Yes, Your Honor. He wants to go back to standard. He was telling me that there's some new children that the respondent has, and he would like his son to have a relationship with those younger children.
Do you agree or do you disagree with that, Ms. Moreno?
I disagree.
The respondent being Ms. Moreno?
Yes, Your Honor.
So, Ms. Moreno, what Mr. Garcia is saying is that he wants to give you more time with your son because you have more children and he wants your son to have a relationship with them, which normally parents don't come in and say that they want the other parent to have more time. And normally, if that happens, and rarely that happens, the parent says, I would like more time, but you're saying you don't want more time.
I'm gonna speak, Your Honor.
Yes,
I
absolutely.
I was being a petition to get full custody of my child. I requested for him to get visitations and I get sole custody of Antonio. I also filed in the Thompson Reuters. I filed exhibit A1. I don't know if you can see it, of his last 4 years academic records. He's been moving from school districts. In 1 year, he has moved like 2 times school districts and from city to city.
All right, so let me ask you, I'm gonna, if there isn't an objection, Mr. Garcia, Mr. Gonzalez, or Ms. Moreno, let me ask you some background questions, and these questions are gonna be based on some information that I've learned from talking to your son. I'm not gonna get into the merits of the case. I just want to put you all in a good place for just factual background because it's either true or it's not true, right? So, Ms. Moreno, Mr. Alatorre, I'm gonna ask that you raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth to help you God?
Yes, Your Honor.
Both have answered yes. You may lower your hands. You're the petitioner in this case, Mr. Alatorre. Mr. Alatorre, is your true and correct name Antonio Alatorre III?
Yes, Your Honor.
Mr. Alatorre, do you have any children with Ms. Moreno?
Yes, Your Honor.
How many?
2.
Their ages?
Believe 12 and 13. 14.
12 and 14?
Yes.
But the child that we're here is only one of those children, correct?
Yes, Your Honor.
The age of that child?
He is 13.
Antonio 13, Santiago is 14.
We're here talking about the 13-year-old, and he is male?
Yes, Your Honor.
All right, and he's the person that the court interviewed today?
Yes, Your Honor.
All right. Any disagreement with those set of facts so far, Ms. Moreno? You have 2 children with Mr. Alatorre. The 13-year-old boy is the reason we're here. True or not true?
True.
All right. Mr. Alatorre, where does your son, the 13-year-old, go to school?
He goes to Decker Middle School,
Where is that?
Austin. Maynard.
How long has your son lived in Austin?
We moved to Austin after Christmas break.
So in January. So in January of this year?
Yeah.
And before that, where did your son live?
We were living in San Antonio.
How long did he live in San Antonio?
We lived there for a little bit over a year.
When you say we, is this you and your son?
Yes, I live with my sister.
When was the last time your son lived with Miss Moreno?
I believe it was 2000, I'll say 17 or 18.
All right, so let me get some confirmations or some objections to these factual presentations to the court. Ms. Moreno, Mr. Alatorre says that your son goes to school in Maynard, Texas. True or not true?
Yes, Your Honor.
He also told the court that your son moved to Austin January of this year. True or not true?
Yes, Your Honor.
He told the court that he lived, your son lived in San Antonio with him and his sister for a year. Was that true or not true?
Can I make a statement on this?
Sure, but just tell the court, is it true or not true?
I don't know.
Okay, so maybe. So, but do you dispute that that could be true?
As what his sister stated in our Spencer, she said they don't live with her.
All right. And so I will take that as possibly not true, but maybe. And then he said that your son last lived with you in 2017. Is that true or not true?
Yes.
All right. So factually, that's roughly confirms what the court heard earlier from your son. Everybody agrees to the facts. Now, how that plays out and how the law applies to those set of facts will become relevant. I'm going to mark this case as the second contested case. If there's no agreement, then I'll list it as contested. But I guess what I need to hear by way of argument first, and you're the person that's moving, Mr. Garcia, tell the court why the court shouldn't continue with those temporary orders and convert those into permanent orders. What's different? What is the evidence going to show?
The evidence is going to show that initially back in the summer of last year, Your Honor, my client, there was an incident where his son, Antonio Latorre IV, was with his brother Santiago. And from what my client tells me, Santiago has some issues or he gets into trouble a lot. And so that's why he came and requested a modification so that the mother wouldn't have the child as much so that he doesn't spend as much time with Santiago. And that's why we got the modification done in November so that she would have less time with the child. But from what my client tells me now, he would like for the mother to have some more time, at least standard visitation, so that that his son can have more time with his siblings that are, I think he was telling me 2 years old.
Ms. Moreno, tell the court before we began. So I just need some background. So you tell me, what do you think the evidence is going to show to support your position?
That our other son Santiago, he has ADHD and OTD moderate, and he was going through some trouble himself, and that I had also been in the position of Mr. Latorre where I don't want Antonio to be involved in this, in what had happened before when Santiago had his problems. I do have other children that are related to our sons. I do have 5 other children, and 2 are teenagers, and he is the uncle. He already also has a nephew. But I did try to communicate with Mr. Latorre, and he's aware that when Santiago had problems, I never intended to pick up Antonio, only for the summer, which is an extended summer, but then also he started, the problems elevated. And there's
With problems with
Santiago.
with the other person,
Yes,
with the other child. So again, to crystallize, make that clear to the court, what's happened since the temporary orders or since the last set of final orders that changes your situation, Mr. La Torre's situation, or Antonio's situation, your son, before this court, that now makes it Antonio's best interest that he live with you?
Your Honor, the temporary orders, I still don't understand why they were put in place. I understand now that they were because of Santiago's behaviors. But before that order, we already had standard degree order that was in place, and there was no communication from father. Like there was no, and since he wasn't in only one place, I would have to be finding my own information, trying to find out where my son was. Because that see that he feels for his safety.
I would be very concerned if what you're saying was true, and Mr. La Torre would say, I want less time with his mom. He's saying, I want him to have more time. But I guess the question the court has is, I think everybody here has agreed that Antonio hasn't lived with you since 2017. So in order for the court to grant your request, and I don't know that I should, it depends on what the court hears by evidence and testimony, but the question is, what's different in 2026 that didn't happen between 2017 and 2026 that changes your situation, Mr. Alatorre's situation, or Antonio's situation, that now it's a good idea and it's in Antonio's best interest that he now live with you? What do you think the evidence is going to show?
I actually got a lawyer 5 years ago to get full custody, but Mr. La Torre had agreed to give me Santiago because of all the issues he had. So I was recommended.
So Santiago, nobody's arguing that Santiago isn't good with you. The question is on Antonio. What is different that Antonio should now live with you?
I obtained the proof where at first Antonio was registered by his aunt at schools, and then I already have the information to provide to you where he's been moving from schools to schools, and he doesn't have a stability.
No, you may not. I'm talking to.
I also have
Ms. Moreno.
where my children told the police officer that the father beats them up because they asked to see me, their mother. And they also had run away from that because of those issues.
These are the children that are in your possession.
From Antonio and Santiago, but mainly Antonio. I have the report and I submitted it where Antonio, the child, actually tells the police officer this stuff. So I have new findings, and I now have the proof of everything that has been happening. Because before it was just the children said this, the children said that, and I didn't have the proof to bring to the court.
If there is no agreement, I'll have to listen to your stories under evidence and testimony. So, Mr. Gonzalez, anything to add to the record before I put this case on pause and hear the first contested matter?
No, Your Honor.
All right, Ms. Moreno, Mr. La Torre, stand by. I'll hear your case momentarily.
Next case from Mr. Garcia, page 5, number 14.
Elizabeth Adriana Alos Fernandez versus Jose Antonio Fernandez Perez, cause number 2025 FLB 1530C3. Court marks Mr. Garcia present and participating by video conference. Elizabeth Fernandez, Jose Perez, are you present? Step in front of the microphone and tell the court, are you Elizabeth Adriana Alos Fernandez?
Para servir.
Yes.
Welcome to court. The court marks you present in person. As you can see from the screen, your lawyer is present by video conference. Are you Jose Antonio Fernandez Perez?
Yes, sir.
Welcome to court, Mr. Perez. The court marks you present in person. Mr. Perez, do you have a lawyer? Speak into the microphone.
No, sir.
Will you be going forward today without a lawyer? Are you asking time to hire a lawyer?
No, no.
Are you going forward without a lawyer?
Yes.
Would you like to continue today or do you want more time?
Today.
So you want to go forward without a lawyer?
Yes.
Court marks you self-represented. Mr. Garcia?
In this case, Your Honor, I believe the parties have an agreement and I did have already a proposed final decree. I don't think the respondent, Mr. Fernandez, hasn't, I don't know if he's seen it, but we're ready to proceed today, at least to prove it up, Your Honor.
All right, so Ms. Fernandez, Mr. Fernandez, I'm gonna ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes. Yes.
You may lower your hands. Mr. Garcia, one witness at a time, go ahead.
Thank you, Your Honor. Can you state your name for the record, Ms. Fernandez?
Elizabeth Fernandez.
Elizabeth Fernandez.
And you're getting divorced from Jose Antonio Fernandez Perez?
Sí.
Yes.
Okay, and you have been living in the state for the last 6 months and in this county for the last 90 days.
Sí.
Yes.
And you and your husband you were married on or about September 14, 1991?
Sí.
Yes.
And you got separated May 2025?
Yes.
Yes.
Okay, and the reason that both you and your husband are getting divorced is because you and him no longer get along?
Yes.
Yes.
And there's no expectation of reconciliation between you and him, is that correct?
No.
No.
Okay, and all the children that you have are already over the age of 18?
Yes.
Yes.
And you're not expecting to have any other children with your husband, is that correct?
No.
No.
Okay, and when it comes to the division of property, Ms. Fernandez, you already have an agreement with your husband, is that correct?
Yes.
Yes.
Okay, and the agreement is that you're gonna be keeping all the money that is in your bank accounts, is that correct?
Yes.
Yes.
And you're also gonna be keeping $59,951.57 that is in a certificate of deposit with Allied Bank account ending in 3432.
He's gonna give me?
Yes, you would be keeping that money from the certificate of deposit that's an Allied Bank.
Yes.
Okay, and you're also keeping the Ford Windstar van 2000,
Yes.
Yes.
and you're also keeping whatever personal effects are in your possession.
Yes.
Yes.
Okay, and Mr. Fernandez, he's keeping whatever money he has under his name. Is that correct, in his bank accounts?
Yes.
Yes.
With the exception of the $59,951, is that correct?
Yes.
Yes.
Okay, and then he's also keeping out of that same certificate of deposit with Allied Bank, account number ending in 3432, he's keeping $24,337.92. Is that correct?
Yes.
Yes.
Okay, and then he's keeping all the money that's in the Allied Bank savings account that ends in 9648.
Yes.
Yes.
Okay, and then he's keeping a Volkswagen CC 2018.
Yes.
Yes.
And he's also keeping whatever other personal effects are in his possession.
Yes.
Yes.
And then when it comes to debts, you're keeping whatever debts are under your name.
Yes.
Yes.
And he's keeping whatever debts are under his name.
Yes.
Yes.
Okay, and then there was whatever houses and other properties that you had, you guys already did deeds transferring the properties to the party that's gonna keep the property, is that correct?
Yes.
Yes.
Okay, so and then you're not requesting a name change, is that correct?
No.
No.
I have no further questions for Ms. Fernandez, Your Honor.
Mr. Fernandez, do you have any questions for Mrs. Fernandez?
Muchas.
A lot.
¿Cuál 2018 Volkswagen?
What 2018 Volkswagen?
Es 2010 de Volkswagen.
The Volkswagen is 2010.
All right. Any other questions for Mrs. Fernandez?
Para mí,
It's for me?
pues, oí algo de 59,000, o sea, yo más le tengo que dar de mi cuenta $50,000 de algo y habíamos quedado entre ella y yo.
The agreement between me and her was that I was going to give her 59,000.
Okay. 50. No, only 50. No, 50.
Eran 50. It was 50, not 59.
De mi alma, o sea, de mi cuenta que yo tengo, le voy a dar 50.
The count from the count that I have, I'm going to give her only 50. Only 50. 50.
Do you have any other questions for Ms. Fernandez?
No.
Mr. Garcia, any questions for Mr. Fernandez?
Yes, Your Honor, just one. So on the, are you saying that on the $59,951.57, you did not agree to that, you agreed to 50,000?
Lo que pasa es que ya le dije 9,000 a ella aparte.
The thing is, I already gave her 9,000.
Fuimos en el Beni, no tuvimos.
When we went to Dennis, I gave you money.
Sí,
Mr. Garcia, any other questions for Ms.?
Yes, and on the other points of agreement, you don't have a disagreement on, you just have a disagreement on the 50,000.
Yes, everything else is fine.
That's the only question that I have, Your Honor.
Well, I appreciate the thought about agreeing, but you need final orders. So either you need to reach an agreement or you need to.
Perdón, discúlpeme, sir, discúlpeme.
I'm sorry, sir.
So either you can reach an agreement or you can, through evidence and testimony, prove to the court who is entitled to those $9,000. Mr. Garcia?
My understanding was that there was an agreement as to that amount, Your Honor. He's just, I'm just knowing about this right now.
I can do one of two things. I mean, it's almost 4. I can schedule this 30 days out, or perhaps maybe if the parties talk between now and Thursday, I can set it for prove up on Thursday. Mr. Garcia?
I don't have any objection to that, Your Honor.
Mr. and Mrs. Fernandez, usually if there's no agreement, I can schedule things 30 days, 45 days out, but it sounds like you can reach an agreement, whatever it is, and you can come back and prove up whatever your agreement is on Thursday. Do you agree or do you disagree with that, Mr. Fernandez?
Fix the problem right now.
And how do you propose to do that?
Give her the money that she's requesting.
Is it your agreement to then pay her the 59,000 that she's requesting?
First is my health and money.
So Mr. Fernandez, I don't want you to ever feel pressured or coerced into doing anything. This court needs to do whatever is just and right, and you and all parties get to tell the court what you believe that is. So I'm not here to tell you to do anything unless you either agree to it or you prove up what you believe is just and right. Would you like some time to talk to Ms. Fernandez?
No, whatever she asked for, that's fine.
You're under oath. Do you believe that 59,000 payment to Ms. Fernandez would be a just and right division?
Yes.
Mr. Garcia?
We would have no objection with that, Your Honor.
Ms. Fernandez, you heard Mr. Fernandez say that he had paid you some money in the amount of 9,000. He thought that he had already paid you some of that amount. Is that true or not true?
Lo que pasa es que él tiene una cuenta que se vence en mayo y habíamos hablado y me dijo que en mayo me daba y lo que el abogado vio que tenía en su cuenta son $87,000, bueno, más intereses,
Understood.
y en su cuenta
Translation, please.
35,000. Entonces la mitad es,
The thing is that he has an account that expires in May. And when the attorney saw it, he said he had 87,000 and then 35,000 was the division.
So ostensibly, Mr. Garcia, what your client is saying, and if this is incorrect, then you need to correct the court, that you just divided the assets on hand at the day of the final hearing.
No, Your Honor, we had talked about it since before, and I did go over the accounts with my client, and she had told me that that was the agreement that she had with her husband. That's why I put those amounts.
All right. Well, the court has heard a Rule 11 agreement stated on the record. Mr. Fernandez, do you disagree with any of this?
No, everything's fine.
Mrs. Fernandez, do you agree with all of this?
sí, había una cantidad ahí que andaba volando, pero él me hizo cuentas y pues ya, o sea, como dice él, ya con tal de que se acabe esto, ya, que se quede con eso y ya.
Yes, there was an amount that was pending that was up in the air, but like he said, just to get everything done and finished, yes, that's fine.
Ms. Fernandez, you're under oath. Do you believe that this agreement is in fact a just and right division of your marital property?
Sí, la camioneta que me dejó en la mañana no prendió, él se quedó con una casi nueva.
The truck that he left me didn't start this morning. He kept on almost new one, but yeah.
Fue al correo y se me apagó también, pero it's okay.
I went to the post office and it wouldn't turn on, but that's okay. That's fine.
All of that is good and it's important, but it doesn't answer my question. My question is, this agreement that you have with Mr. Fernandez, is it a just and right division of your marital property?
Yes, sí.
Yes.
Same question to you, Mr. Fernandez. You're under oath. This agreement that you have with Mrs. Fernandez, do you believe that this is a just and right division of your marital property?
Yes.
Anything else, Mr. Garcia?
No, Your Honor.
Mr. and Mrs. Fernandez, in your case, cause number 2025 FLB 1530C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage, but that marriage has become insupportable due to a discord or a conflict of personalities. That destroys the legitimate ends of the marriage relationship. The court finds that you have an agreement regarding the division of your property. The court hereby adopts and approves your agreement and finds that your agreement is in fact a just and right division. Mr. Fernandez and Mrs. Fernandez, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and the orders are due to the court honor before
April 27th at noon by submission.
that concludes your case. Mr. Fernandez, do you have any questions for the court?
Thank you for everything.
That concludes your case. Mrs. Fernandez, do you have any questions?
No, it's okay, thank you.
Ms. Flores, does the court have Mr. Fernandez's email address?
Yes, Your Honor.
All right. Mr. Fernandez, Ms. Fernandez, I wish you all the best. Have a good day.
Gracias.
That leaves one case that hasn't been called on today's docket, page 8, case 22. Maria de Lourdes Johnson Contreras versus Mario Alberto Ortiz, cause number 2026 FLF 69C3. Claudia Nancy Garcia or Brenda Anderson. Is any counsel present other than Mr. Raul Gonzalez, who is no longer present? Yes, Mr. Gonzalez is present. Mr. Raul Gonzalez is present. He's participating by video conference on behalf of the Attorney General's office. No other lawyers are present. Maria Lourdes Contreras, Mario Alberto Ortiz. Any parties present? Court finds no parties present. Ms. Flores, any filings? You from the clerk's office, any filings?
No, Your Honor.
All right, court finds no party present. Give me one more setting, please.
Yes, Your Honor, that'll be May 5th at 2 p.m.
All right, so ordered. All right, the court will stand at ease and go into evidence and testimony first on the Hernandez Maldonado case, and then the court will go into evidence and testimony on the Moreno a la Torre case. Stand by, please.
Can you fire the river?
Mike.
Audio in courtroom muted. Please unmute courtroom audio.
Good afternoon. Court is back in session. The court is going to go into its first contested case on today's afternoon docket. This is Raylene Hernandez versus Martin Ramiro Maldonado III, cause number 2024 FLI 1859C3. Court marks Mr. Del Rio present in person, Mr. Peña by video conference, Mr. Raul Gonzalez present by video conference. They are the lawyers in the case. Present in person are both Raylene Hernandez and Martin Maldonado. They are the parties. Mr. Peña, Mr. Del Rio, what is the announcement?
Well, we've agreed to most of it, Your Honor, but we have not been able to agree to the frequency of visitation or the cost, who's going to bear the costs of travel for visitation. We've sorted everything else out, and we've kind of limited it to those two issues. My client lived in Webb County, and then she moved to the state of Washington, and then shortly thereafter, Mr. Del Rio's client filed this motion.
Sorry, the last thing you said was after, subsequent to that, Mr. Del Rio's client did what?
He filed this motion. He filed this motion.
Well, Mr. Peña, Mr. Del Rio, put into the record the agreement that you do have. We'll confirm it and we'll take it from there. What agreement do you, what agreements do you have?
I think we have. I don't know, Mr. Del Rio. Did we agree on Thanksgiving, Christmas, and New Year's?
Attorney table off.
I don't think we, don't think, we didn't have an agreement, Your Honor. I think the scope of the agreement was what was contested, which was frequency of, which is basically the visitation schedule for the children, taking into account the geographic distance and the cost for transporting the children for father to exercise his visits. So there was no agreement, Your Honor. It was just, we agreed to, those were the key issues in this. And after giving you testimony, we were going to ask for Your Honor to make a ruling as to both of those issues. As far as holidays, I think perhaps we could say that we don't be okay with standard visitation. But again, I think, Your Honor, we would leave that open to you, given to maybe allow you more flexibility to craft a order that takes all of that into account, Judge.
I agree with Mr. Del Rio. I guess as far as the agreement is concerned, I filed an amended petition alleging, or rather asking for other relief. We are not going forward on that amended petition, and we are limiting the scope of this matter to exactly what Mr. Del Rio just described.
So let me ask Mr. Del Rio and Mr. Peña. These are the facts that were presented to the court at 2:44 p.m. this afternoon, and there was no disagreement. Mrs. Hernandez and Mr. Maldonado enjoy sharing two children, a 2-year-old female and a 4-year-old male. They live with Ms. Hernandez, who has recently moved to Washington State, and Mr. Maldonado lives in Webb County. Is all of that factually accurate, Mr. Peña?
Yes, sir.
Is all of that factually accurate, Mr. Del Rio?
Yes, Your Honor.
So let me ask you both this, being well-versed in family law, given all of these things, the Texas Family Code says that certain things should happen in these type of situations when the children live with one, parent moves, and then you just apply, you courts, people, persons, lawyers, litigants, parents, just apply the standard visitation for persons living more than 100 miles apart, and you apply everything standard. I don't know who, but I guess we're here because one person in this equation disagrees with standard applying, and ostensibly that the facts, circumstances, and situation of Ms. Hernandez and or Mr. Maldonado would allow the court, after hearing evidence and testimony, to deviate from standard. Who here disagrees with standard? And what would the evidence show in support of that argument?
Well, I suppose we have some disagreement with standard in the sense that my client has suggested and offered 4-day periods of possession during certain months of the year instead of the standard visitation. And so that's one difference. And
which you believe is what?
They, for example, my client is suggesting February, April, June, September, and November, each of those months, that the father get 4-day periods of possession. That's one way in which what we are asking for is different from standard. And I think perhaps the parties got
instead of what?
I'm sorry?
4 days instead of what?
Can I add to that?
No, I want an answer to my question. 4 days. So you offered 4 days instead of standard. What do you believe standard is?
I believe, well, the father can elect, I suppose, and I don't think an election has been made here. But I think that they can keep it first, third, and fifth, but they have to pick one. Or I'm not sure by memory what the other option is, Your Honor. But the proposals have from both sides have made attempts to customize the standard order.
So both sides are requesting deviation from standard. Mr. Del Rio, how is your client?
Your Honor, the standard, the issue from both perspectives would be the surrender of the child to the other person's possessory period, because that would require travel to another state and pay for flights because the children cannot fly unaccompanied. And so on a date where my client is supposed to return the child so that to the children to mother at her residence, in those circumstances, we're objecting to that because my client would have to literally fly them all the way back to Washington. Where mother is supposed to surrender the children to father on those periods for his periods of possession, they're objecting to having to pay for the flights exclusively. And so that's the issue, is the cost that is borne and who should bear it when they have to surrender the children to allow the other to exercise their periods of possession.
Other than the surrender, and I guess the payment associated therewith, Mr. Del Rio, what is your client's position, or is there a disagreement as to the dates?
As far as the dates, we would be okay with allowing him under the code to elect his weekend of visitation once a month. That's an option, because as Mr. Peña was pointing out, he has the right to exercise his first, third, and fifth weekends, or he can elect one weekend per month throughout the school calendar year for the child. And we would certainly be okay with the standard for summer and the standard for holidays. Again, it's more of a question of the cost of transporting the children, and that's what the testimony would get into. Or an issue, I said, not a question, it's an issue of bearing that additional cost of traveling.
Let me ask you both this. I mean, we're dealing with two very small children. I'm not familiar. Will the evidence on one side or the other present any evidence as to the ability? Don't certain airlines allow travel of children unaccompanied? And I don't know if you rent a person but you pay for a service. Is there something that happens between here and San Antonio or Austin or Houston, the nearest airport to Laredo? So number one, is service an option? Is that service an option? And number two, are these children old enough for that service?
To your first point, it is an option, but to your second comment or question, the children are not old enough. It's generally 5 to 14. And they're allowed to rent. They have to pay for the flight, and then there's an additional $150 fee for the stewardess they sit in a special aisle. They're with the stewardess, and so that's where the additional fee comes in. But they don't qualify yet. Well, at least one of them does, the 5-year-old, but not the 2-year-old.
Right.
It's 4. I'm so 4-year-old. Thank you. So not even the oldest would qualify at this point, Your Honor.
So let me ask you this, and I'll ask you the same question, and I'll start with the petitioner, you, Mr. Del Rio, and I'm going to ask the same question to Mr. Peña right after. What evidence, information, and testimony will be presented here that, if taken as true, would allow this court to do anything other than a 50-50 split for travel, Mr. Del Rio?
So, Your Honor, since Texas law does not specifically cover who bears the cost.
Right.
Generally, the practice is the person that created the expense would bear, but Your Honor would take into consideration the reasoning behind the move, whether it's in the best interest of the children or the parent. And so we believe that the reasoning for mother's move through testimony would be that it's for the best interest of, or essentially, her boyfriend.
Well, hold on, Your Honor. Either we're agreeing that we're not going into child custody.
It's just so, Mr. Peña, it's just argument. I don't take it as true.
Yeah.
In fact, what case law would suggest to the court is that if a move, for any reason, betters the adult parent, then almost by osmosis, it benefits the child. So I don't take it, number one, as evidence or testimony. And I know that there's a counter argument that Mr. Peña is likely to make that lies directly with what I just said. So there's a point, and there'll be a counterpoint. Mr. Del Rio.
The other thing would be, Your Honor, and I was just pointing that
My
reason
question
why
was, what is the evidence going to show? And that's what you believe it
Right.
will show.
And we also believe that, again, the distance that was created would interfere with what is required or strongly encouraged, the frequency and continued contact between my client and his children. That the distance is disruptive. Unless.
But is there, and I don't, I'm not arguing, I just need to understand, is there a counter petition for the exclusive right to designate residence on behalf of Mr. Maldonado?
No, Your Honor.
So we're
Well,
not, so
actually,
he's not arguing
I'd have
here,
to double check the pleadings on that, Your
but the argument here isn't going to be that they're better off with him or that he's asking for them. The question is just how to best effectuate the visits, right?
Honor. I believe so, Your Honor.
All right. So same question, Mr. Peña. What do you believe in evidence and testimony will be presented momentarily that would allow the court to do anything other than splitting the cost?
Well, Your Honor, I don't think there's going to be a whole lot of testimony to that effect, frankly. I think our position is that we're okay with splitting the costs. He just wants, I think the problem is that opposing counsel wants us to pay more than half. That's, I think, where we are disagreeing.
Maybe I should have started there. Mr. Del Rio, what is it that your client is requesting at this hearing?
So, Your Honor, I guess. Are you eliciting sort of an
Tell me where you're going so that I know what roadmap you're going to travel. Tell me what it is you're asking.
So we're asking, Your Honor, that that mother be substantially responsible for the cost. We had made concessions of I guess, oscillating months of visitation so that cost is not repeatedly borne on mother every month. And my client had made some concessions about allowing him paying the cost for the children for some of the larger extended periods like summer and spring break. I think we were amenable to allowing my client to reduce the frequency only if, we reduce the child support to offset the expense that he would have to bear. And the testimony would also go into the cost he would have to bear, not only if he were to split it with mother, but if he would have to travel up there, taking into account that he's already paying child support.
But the court heard from you, and I'll ask Mr. Peña the same question momentarily, but the court heard from you that at some point, without getting into specifics, an oscillating payment schedule or responsibility was discussed.
Oscillate, yes, but not, I guess, no, well, when you say oscillating, it sounds more like.
I'm using your word.
It would be more, it was suggested on extended periods of his possession. So for example, if he's going to have summer for an extended period summer, he would volunteer at some point to pay for the children to travel down, and then he would fly for them to leave. For the shorter in-school visits, we had suggested that mother pay for those. However, to help her out financially, there was discussion of alternating months. So January and skipping February and then going to March and then skipping April. So that's what I mean.
Tell me if I'm wrong, if I am, Mr. Peña, but isn't that what you offered?
We offered, yes, we offered February, April, June, September, and November.
Isn't that what you just said, Mr. Del Rio?
There were some caveats to that, but yes, they did offer that. We'd offered January, March.
So at least you have a rough agreement. You just need to iron out the specifics. What are the non-agreed to specifics?
Let me, yes, Judge, let me pull up.
The cost is the primary one, and the 42 days during the summer there's some disagreement. We agree in principle as to
it sounds like Mr. Del Rio's client agrees to pay for the longer extended one, so that would cover summer, so he's agreed to pay that. But here, the disagreement is what? Because it sounds like one parent would pay 1 month and then the next month the other parent, and so on and so forth. And look, just knowing what the court knows, not about this case, but about travel in general, if you make one person responsible for the full bill, no one would ever, what I don't want is I don't want to come back to court and one person tell the court, this person, the other parent, stuck me with this huge bill. Had I been able to book the flight, I would have gotten it at 20% off, or I would have used points or whatever the case is. So it sounds to me like it is in, forget the children, but in the financial best interest of each party to bear the full responsibility for travel during one period of possession, because that person is responsible for finding the best flights versus having to rely on the other person, and who knows what flights they're going to choose.
Well, that's true, Your Honor, and I guess if
quite frankly, I mean, not that well, go ahead.
well, we're obviously you're up for the task, Your Honor, but Mr. Benny and I are sort of handing this this big decision over to you. Would it be helpful, Judge, if we turned over to you our competing proposals to give you sort of a roadmap? It's much more easier to read it than for us to try to tell you back and forth. And then the only thing I guess we could limit the testimony to would be our basis for what mother moved up there for, and then they can argue or they can listen to testimony what her reasons were, because you said there were competing points as to both of those.
Sure.
And then perhaps put up the financials of my client and expenses, and they can do the same. Because I think that you have the evidence or the facts to sort of say, well, look, based on both of your proposals, I can hedge it this way or that way based on the testimony.
Well, that sounds
Your Honor,
straightforward and reasonable. But it sounds like that's what we're going to do. We're heading in that direction in the event. All right. Anything else, Mr. Benny, to put on the record before I place the witnesses under oath?
1 second, Your Honor. No. Might I inquire, though, before we begin, Mr. Del Rio wants to get into the reasons for moving. And if we're not agreeing to change custody or the exclusive right to determine the residence, I'm not sure why that's relevant to this issue, Your Honor. She did not break any court order. She did not have a geographical restriction. I'm not sure that this issue requires the court to make a finding of whether somebody had a good reason or a bad reason to leave. We would object to any testimony to that regard.
I don't disagree with you, Mr. Pena, and I don't know if Mr. Del Rio, I guess the natural logical extension, the full extension of his argument, and I can't disagree with any of this, but not yet anyways, but it sounds like he wants to put on evidence and testimony in case I rule in your favor. He's going to take it up for review based on the testimony as to the reason for the move. And I don't know. I don't know what the answer is because I don't know what the testimony is either. So
well, Your Honor, but it puts me in a strange position because I can't really question him about his reasons for staying. I mean, I'm not sure that even works. So if when you put it in that context, it puts us at an automatic disadvantage. We already know we're the ones that left. That's all Your Honor has to really take into consideration.
The venue is Webb County, and we are here. So ostensibly, the court's jurisdiction would the fact that this is the proper court form and venue would answer and resolve that question. There was a move, and I guess the court needs to hear evidence and testimony. I don't know if it's going to work out the way Mr. Del Rio, it may or may not. I don't know, but you're entitled to cross-examination. This is your petition, Mr. Del Rio. Who is your first witness?
I'll call my client, Your Honor.
Mr. Maldonado, step in front of the lower microphone on the lower bench, and let me have court staff turn on the witness stand. I'm gonna ask that you raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I swear.
You may lower your hand. You may have a seat here on the witness stand. Give us a second while we test your audio, turn on your video. As that happens, you are under oath. The lawyers are going to ask you some questions. Pause your answer until you hear the full question. If you hear one of the lawyers object, pause. I'll tell you if you can answer. Mr. Del Rio, whenever you're ready.
Thank you. Mr. Maldonado, what do you do for a living?
I work as a deputy for the Webb County Sheriff's Office.
Okay, and how much do you take home monthly from your job?
Monthly after taxes would be about 2,200.
Okay, and is that also after child support and medical support have been removed?
Yes.
Okay, now, how much do you pay monthly for child support?
530 bi-weekly, so it'll be 1,060.
Okay, now, are there certain months where you receive more than 2 paychecks in that month?
Yes, 2 months out of the 12-month period, I received 3 paychecks.
Okay. And you said 500 and how much is your monthly or bi-weekly paycheck, excuse me?
Bi-weekly check, my paycheck after taxes would be 1,100.
Okay. Now, how much are you currently paying in medical? How much is the Attorney General's office deducting for medical support?
Currently 300 a month.
And is that per paycheck or per month?
Per month. So
Okay.
150 a paycheck.
Okay. Now, as far as what is your work schedule?
It ranges. I'm a full-time deputy, so every 2 months, it would switch from 6 a.m. to 2 p.m. and then 10 p.m. to 6 a.m. and then 2 p.m. to 10 p.m.
And how many days a week do you work?
5.
Okay. And is it a Monday through Friday work schedule?
So Saturday through Sunday.
Saturday through Sunday. Okay. And can you request or are you allotted time off per month?
Yeah. I am given, or it's earned comp time, so I'm able to use that in regards to anything in particular I can request.
And how much comp time do you earn? How many days of comp time do you earn roughly per month?
Per month, roughly about 24 hours.
Okay, now, have you looked, okay, so have you already purchased in the past a flight for your 2 children to travel from Texas to Washington?
Yes.
And how much was the flight round trip for both of the children?
Round trip was 475.
Okay. And that was flying out of which city in Texas?
From San Antonio.
And that was flying them into which city in Washington?
Seattle.
Okay. Now, have you looked into the cost of traveling out of Laredo, Texas to Seattle, Washington for one person?
For a round trip, one person would be particularly around 450 per person in Laredo.
Okay. Now, have you also looked into the average cost of a hotel per night in the city of Seattle?
Yes, I have. It's roughly around 125 a night.
Now, you don't have a vehicle in Seattle, do you?
No.
Have you looked into the cost of renting a vehicle in Seattle if you were to travel to visit your children?
Yes. Around 20 to 25 a day.
All right, yeah. When, so the court's aware, when is your son's birthday?
My son's birthday lands in September 25th.
And when is your daughter's birthday?
Daughter's birthday is June 28th.
And did you get to visit with your children on Father's Day this year?
This year, for Father's Day, I did not.
Now, in regards to holidays, well, I should ask you this. Did you get to visit your children for their respective birthdays in September and June of this year?
Of last year, yes, I did. Or
Okay,
yes, of last year, yes.
Okay, thank you. Now, as far as the Christmas holiday for 2025, who had possession of the children?
Ms. Hernandez.
Was it her year to possess the children for the Christmas holiday?
Yes, it was.
Okay. For the New Year's holiday, beginning in 2025 and continuing into 2026, who had possession of the children?
Ms. Hernandez.
And whose possession period was that supposed to be?
Mine.
Okay. Now, as far as, have you had conversations with Miss Hernandez about why she moved to Seattle?
Yes.
Okay, and has she told you why she has moved to Seattle?
Yes.
And what did she tell you was the reasoning she moved to Seattle?
The reasoning was because it was in the best advantage for her boyfriend.
I'm sorry, say that again?
It was in the best advantage for her boyfriend.
It was in the best advantage for her boyfriend, is that what you said?
Yes.
Okay. Did she tell you that she got a better job there for moving to Seattle?
No.
Okay. And you said boyfriend, so they are not married or engaged, correct?
Objection, Your Honor. Why are we?
No.
It's irrelevant, Your Honor. I mean, why are we getting into these facts? We're talking about the scheduling.
What is the relevance, Mr. Del Rio,
The relevance, Your Honor.
into the record?
Yes, Your Honor. The relevance would be that she is in a relationship with a man who is not the father of the children or set to be a he's still a paramour, Judge, for all.
So what, Your Honor? So what?
And
literally, so what?
But
People
is
can
this-
have
is
a
it,
private life, Your Honor.
I
That's not
I
fodder for this.
understand. I understand. So is this a divorce?
No, Your Honor.
And if the court were to hear evidence as to whether this person is married or not married, boyfriend or not boyfriend, how would that impact a ruling on payment for visits?
Well, Your Honor, because the best interests of the children are primarily the court's consideration, and if they are,
But so to the court's question, and I'm not fishing for a specific answer. I really want to know. So if the court finds that mom is married or mom is not married, how would that change the calculation of the payment for flights on visits?
well, Your Honor, it would go again to the equitable argument that she is moving not to enrich either herself or the children's benefits.
Let's say I make that finding, and I haven't heard enough evidence to make that finding, but let's assume you get there. How does that impact the calculation of flights?
Well, because Your Honor, she has made a move that is to the detriment of her children by.
Your Honor, if we're going to get into the best interest of the children, then we need to have a hearing, a full-blown hearing, Your Honor, because he
So
keeps
that-
talking
that's
about the
not
best.
an
If he
objection.
doesn't
That's
think
not,
this,
that's not an, to stop. That's not an objection, and we're not doing that.
well, Your
We're
Honor,
not
I think
doing
it's irrelevant
Like,
that he's getting to the
I
best
need an
interest of
answer
the
to my
children. We're
question.
not. We've already agreed on that.
Mr. Peña, the question actually goes to your argument and is about to be sustained. But before I sustain your objection, I want to give Mr. Del Rio a fair shot at getting an overruling. So let's assume the court finds all of that, Mr. Del Rio. Let's assume you're right for purposes and for the sake of argument. How does that change the calculation?
For purposes of argument, Judge, to answer your question, the move is not in the best interest of the child because it is cutting against my client's frequency to visit them, and in doing an unjust burden on him financially. And to your earlier point, Your Honor, the response was that the children are ostensibly getting a benefit, but they're not, because he's not making a benefit towards the community estate that the kids would benefit.
All
Your
right,
Honor, this is
the objection
You'd be
is
asking for custody then.
I can't
It's a
sustain the
schizophrenic
objection when you
argument.
keep interrupting. I
Well,
can't.
because Your Honor, it's schizophrenic what he's saying. He's saying that, then why is he not asking for custody if it's not in the best interest for them to move?
Would like to sustain your objection, but I'm not going to do it by talking over you. Sustained. Next question.
Have you discussed how long she plans to stay in Washington State? Or she told you how long she plans to stay in Washington State?
Yes, planning till March 2027.
Now, aside from, you said you make salary of $2,200. That was monthly, correct?
Correct.
Okay. What expenses do you have currently?
Currently,
Your Honor, I object to relevance,
have
Your Honor.
my deduction.
What is the
Your Honor, I object to relevance, Your Honor.
What is the relevance to Mr. Maldonado's expenses?
Your Honor, the relevance would be again to support the equitable argument that my client would be unduly burdened by having to make an expense that we laid out, which would be roughly 500
All right, so
plus.
overruled. You can answer.
So again, what expenses can you lay out for the court that you have monthly that take away from your salary for living?
Right. It'll be my insurances.
And how much are those?
My insurances combined would be roughly 75.
Wait, but those already come out of your paycheck, right?
Yes.
Okay, no, I'm talking about living expenses.
Living expenses.
How much do you pay for rent or mortgage?
I currently live with my parents. I do not pay rent payment, but I do pay for my phone.
And how much is that?
My phone's roughly about 60.
Okay. And
Okay.
do you pay for a vehicle, car payment?
Yes, I pay 500 a month.
Okay. Do you pay insurance for that?
Yes, I do.
And how much do you pay for the insurance on that?
120.
Okay. And do you contribute towards any utility expenses at your parents' residence?
No, I don't.
Do you contribute towards any food expenses at your parents' residence?
Yes, I do.
How much monthly do you roughly contribute towards food expenses living at your parents' residence?
Be roughly around 75.
I'll pass the witness, Your Honor.
Cross-examination, Mr. Peña.
So you're a sheriff's deputy?
That's right.
And how old are you?
31.
You still live with your mother?
I do.
And you're not paying any rent, right?
No.
Objection, Your Honor, asking answer.
And you're not paying any electricity, right?
Sustained. That one you can
Your
answer.
Honor, I'm trying to make a point.
That
I'm going
one-
over evidence that.
No.
I sustained the other one because he had asked and answered it. He had answered it, but that one you can answer.
As for utility, no.
So you don't pay rent and you don't pay utility, but you don't have enough money to pay for an airplane ticket for your kids?
That's right. I don't.
Isn't it true that you're just upset because you still live with your mom and she's gone off and have a life now?
I'm sure for in your circumstances you have before, but I mean, we're talking about the kids right now.
Well, do you have a girlfriend?
I have a significant other.
Okay, but you still live at home with your mom.
Is that a problem?
Well, I'm just saying, isn't it true that she's gone on with her life and you're just upset about that?
No, I have my own life.
Isn't it true, sir, that this problem didn't start until she got a boyfriend?
Not at all.
Isn't it true that this is just you being bitter and jealous and resentful?
Objection, Your
Not
Honor.
at
He's
all.
badgering the witness.
All right.
Let's move on.
So then if you don't pay rent and you don't pay utilities, it seems to me that you have extra money, right?
Objection, Your Honor. That's testimony. Mr. Peña's testifying on behalf of my client.
Sustained. Ask a question.
Well, do you have extra money since you don't pay rent or electricity?
Extra money as in spending money? No.
No? What?
No.
Well, so you said your car was 500.
Yeah, that's
Your car, your phone is 60.
Gas as well.
I'm sorry?
That's not including gas.
Okay, you pay for gas. Okay, so you're barely making it then, even though you live at home with your mom.
Absolutely.
Okay. All right. How long have you been a sheriff's deputy?
For over about a year.
And what is your yearly income?
It's roughly 64 grand.
$64,000 a year, right? And you live with your mom and you don't pay rent, but you don't have enough money to pay your kids airplane tickets. Is that correct, sir?
Absolutely. I mean, these airplane expenses were substantially unexpected, and I don't have the funds to be paying for as
you think
aside
that
from my expenses.
do you think that this would have that you would have complained had she stayed in Laredo?
I mean, as long as I'm able to see my kids, that's my right and that's my obligation to be here.
Okay. Did you want to see them every month or every other month?
That's whatever the court finds best. I would love to see them as many
Okay,
days.
so you want my client to pay for your plane ticket?
Absolutely. I mean, I'm not going to pay for it because I didn't create this distance.
Okay, and who's going to choose the airline?
It can go vice versa.
No. Well, you're going to choose the airline then, and she's going to pay?
Yeah, I mean, if it's
You're going to choose the date of travel, and she's going to pay?
So let me, you all are, it's good that you're talking, but you're not supposed to be talking. So let's hear a question and answer. Mr. Peña.
So then, who's going to choose the time, date, and airline for the travel when you travel?
I would say it would be upon my request of the days pertaining to this, since I'm the one employed, and the location cost efficiently, I would say San Antonio would be the best price.
And you want her to pay for your ticket, right?
If she's gonna fly me up?
No. I'm asking you, do you want her to pay for your airplane ticket?
For me to fly up?
Yes.
If she can't come down? Is that what you're asking?
No, I'm saying for you to fly up to Washington State, do you want her to pay for your airline tickets?
Though, if I'm gonna fly up to Washington,
are you having trouble hearing me?
No, it's just you're not coming in through like clear, because this was about
if you have to travel to Washington State, who's going to pay for the airline ticket?
She is.
Okay. And you think that's really going to work?
Yes, because I mean, aside from me,
will you pay for her
the days off that I work for my job?
When she comes down to Laredo, will you pay for her ticket?
There's an objection. What is the objection?
Your Honor, this is not only relevant, it's not proper questioning, and it's just completely irrelevant for Your Honor to make a decision.
Your Honor, it got into all this
give me one
personal-
second, Mr. Peña. I can't even rule on the objection, Mr. Del Rio, because I don't even know what the question is. I think Mr. Peña and your client are talking over each other. So whether it's relevant or not, I don't know, because I can't figure out what you all are saying. So, Mr. Peña, let's hear a full question. Mr. Maldonado, pause for 2 seconds, then answer, and everybody hold off until the court can hear that answer, and we'll proceed. Mr. Peña, go ahead.
When my client travels down to Laredo to bring the child, are you going to pay for her ticket?
No.
So from your point of view, you should pay 0 expenses for travel to see your kids. Is that correct?
No, I will pay for the long periods, which are spring break and the summer round trip.
So you're willing to pay the round trip for yourself, if necessary, and the children for summer. And what else? Spring break, you said?
I said summer and spring break round trip, correct?
Give me 1 second, Your Honor. Pass the witness.
That was cross-examination. Redirect.
Yes, just briefly, Your Honor, just to clarify, you said you would be willing to pay for summer and spring break for the children's flight only, is that correct?
Yes, that's what we're talking.
Okay. For those, you would not be willing to pay for mother's flight to come down to visit, or excuse me, deliver the children to you. Is that what you're saying?
That's right.
Okay, now, and just to clarify, you testified that your salary was $64,000 a year. Is that gross or is that net?
Gross.
Okay. So if you are receiving roughly $2,204 as your bi-weekly, that's roughly $4,400 per month, correct?
Correct.
And you would agree that that number is less than 64,000 spread out throughout the year. Is that fair to say?
44 should come out 44 times 12. I mean, I'm sorry, times 26 paychecks throughout the year, because 2 months I would get paid 3 times.
Okay. Well, I can't ask you to do the math on that, but at least we have your testimony for the judge's calculation. Okay. That's all. I have no further questions, Judge.
Anything else, Mr. Peña?
No, Your Honor. I'd like to call my client and ask him.
Give me 1 second. Mr. Maldonado, you may step down. This is still your case in chief, Mr. Del Rio. Any other witnesses?
No, Your Honor. I'll rest.
Right now, your case in chief, Mr. Peña, who is your witness?
Raylene Hernandez, Your Honor.
Ms. Hernandez, please step in front of the lower bench and speak into a microphone. Raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. You may have a seat here on the witness stand. Same as with Mr. Maldonado. You're going to hear the lawyers ask some questions. Pause until you hear the full question. If you hear an objection, wait, and I'll tell you can answer. Mr. Peña, whenever you're ready.
Could you please state your full name?
Raylene Hernandez.
Raylene, you heard the testimony a few minutes ago from the father of your child. Is that correct?
Yes.
Did you ever tell him that you were moving for the best interests of your boyfriend?
No.
And did you ever tell him that anything other than you were going to live in Washington State?
No, I was moving to Washington.
Okay, you told him you were moving to Washington.
Mm-hmm.
Is that a yes or a no?
Yes.
Okay, and why did you move to Washington?
My boyfriend he's well established there. He works there. And after some time, I decided to move with him. It was in the best interest of the children and myself. And we moved in June. I was also pregnant. I miscarried in August, but those were the main reasons as to why we moved.
And what city do you live in now?
In Washington, Des Moines, Washington.
And is the child in school there?
My son, he's in school.
Okay. And are you working?
Yes.
Okay, you work with your boyfriend, is that correct?
Yes.
And he owns a number of he owns some real estate in Washington, I assume. Is that correct?
Mm-hmm.
And you help him manage those properties, is that correct?
Yes.
Okay.
Correct.
How long have you been doing that?
Since I moved there, which was in June.
Okay. And is this gentleman that we're referring to as your boyfriend, is he pretty important in your life?
Yes, of course.
And do you love him?
Yes, and I'm pregnant again, so yes.
Okay. And so you plan, this is not I mean, how would you describe your plans for your future relationship with this gentleman?
Well, we have a family and we're gonna have an addition to our family, and we plan on getting married soon, so yes.
Okay. All right, understood. And so would it be safe to say that you went to Washington State to start a family?
Yes.
And is the weather nice over there?
Yeah.
Are the schools good over there?
Yes, for sure.
Okay. And is there a hospital where you live?
Yes.
Okay. And you all are living in a home or an apartment?
We're living in a home.
Okay. And how long have you been in that home?
We have been there since September.
Okay. Now, look, you're the one who moved from Laredo and moved to Washington State, right? Do you acknowledge that?
Yes, correct.
And do you acknowledge that that has caused some friction in the legal relationship between you and the father of your children?
Correct.
And do you understand that you're going to have to bear at least your half of the burden of physical travel and costs of travel? Do you understand that?
Yes, that's exactly what I'm asking for.
You're right. Okay. So am I correct in saying that you're asking basically that the expenses be split down the middle? You will pay for your expenses and he should pay for his expenses.
Correct.
Okay. Let me just look at my notes here very quickly. I don't think I have too many more questions. What is the I know you were concerned about this because you brought it up. Could you please, one of your children is in school and his summer vacation begins when?
He's in school. School ends in June. I have the dates on my notes, not in front of me right now, but it's sometime in like mid-June, I believe.
Okay.
So summer vacation would work until after mid-June, through August.
And do you have any problem allowing a 42-day period of possession for the father during the summer? Do you have a problem with that?
There's never been a problem with visitation or the amount of time that they've been with their dad. Last year they did 44 days actually, not consecutively. They were split up into 3 separate trips, but they've always been with their dad when they're supposed to be with their dad, basically.
Okay. And the problems didn't really start until recently. Is that when you moved, after you moved to Washington, correct?
The problem started when we went to mediation and adjusted child support in September. Child support was adjusted to $1,000 in October. The very next month, November, the kids visited their father, and that's when everything started. The whole incident in November started then, and that's when the issues between, us and the court got involved.
Understood.
Mm-hmm.
Understood. Okay. But, well, I guess.
What I'm
So
trying to point
you
out
are
is
willing to pay for your own tickets and the child's tickets when it's your turn. Is that correct?
yes.
Okay. All right. Well, we were talking about the 42 days during the summer. Now you said you don't have a problem with 42 days during the summer, correct?
Correct.
Okay, but you also told us that the child gets out for the summer in sometime in June.
Yes,
So is it accurate to say that you're asking that those 42 days just take place sometime after the child gets out of school, rather than take him out of school? Is that correct?
yes. For all visitation, I would ask that it's based off his school schedule and the schedule, the calendar schedule for the district he's in. Rather
And
than
you would provide that information to the father of the children?
yes, but he refuses to follow that schedule and says that we're supposed to follow what's Webb County, I guess. I don't know.
Well, yes, I understand. Yeah, you would like, if you, in a perfect world, you would like for the visitation to follow the school schedule. Is that correct?
Yes,
Okay. But you understand that standard visitation for children who live more, parents who live more than 100 miles apart doesn't necessarily follow the school schedule. Do you understand that?
correct. However, the holidays and summer visitation, I think it specifies that it's when the kids are off of school. It doesn't
Yes,
specify.
understood. Yes, you are correct. But you understand that if the father were given standard visitation for parents who reside over 100 miles away, that you would have to comply with that order. Is that correct?
Yes,
You
correct,
understand that?
yeah.
And will you comply with that order?
Yes. Mhm.
Okay, understood. And I believe, let me see, I think that's it. Oh, one other thing. You said you were pregnant, correct?
Correct.
Congratulations.
Thank you.
How far along are you?
I believe around 8 weeks. I have an ultrasound appointment on the 14th, and that'll confirm how far along. At this
8
point.
weeks, so that's roughly like 2 months, correct?
2 months. Mhm.
Okay, so you're still in what they call the first trimester.
Yes, correct.
At some point, traveling is going to become difficult, if not impossible, for you.
Yes.
When would that happen, in your opinion?
It's kind of hard to say because every pregnancy is different. So I don't know. I mean, I think it also would depend on maybe doctor's orders. If they allow me to travel, then that's okay.
Okay, but let's assume that everything goes normally according to plan, like your last your last pregnancy. Would it be the third trimester when you would have difficulties traveling?
Yes, most likely. Both of my children were delivered at 38 weeks, so it was 2 weeks early. So I would say, yeah.
And are you asking the court to accommodate the fact that you're pregnant and that roughly 6 months from now you're going to be somewhat immobilized?
Correct.
And you would give notice of your condition to the father of your children here?
Yes.
Okay, and you would keep him informed throughout the process, correct?
Yes.
Okay, pass the witness, Your Honor.
Cross-examination.
Yes. Mr. Peña said there may be a point where you are immobilized due to your pregnancy. During that period of immobilization, would you allow your children with my client to stay with you for an extended period of time to allow you to have a healthy and successful birth of your new child?
Can you repeat that question? I'm sorry. The last part.
Would you allow your children to come and stay with father?
Oh, father. Okay.
During that time to allow you to have a little bit of relief so you could focus on your pregnancy?
No. The issue is that typically when you're further along in the third trimester, usually you're not supposed to fly. It's not that you can't care for children, it's the flying. So if he's willing or able to get the kids and then bring them back home and, splitting the cost, I think would, I don't know, like there'd be no problem if he's able to just go get them. Because I'd still pay for my portion as long as he's paying for his.
Well,
So the problem is that he doesn't want to go pick them up.
when you say split the cost, you're implying that how would you explain splitting the cost of the flights for the children when one parent has to fly with the children?
Well, just as it's always been done, because this past time where he paid, I had to fly with children. I still paid for my ticket anyway. But what he says is that was split cost. To my understanding, that's not split cost. That's just paying for the kids' ticket, not split, because I had to pay to take the kids and myself or not to take the kids. I had to pay to take, yeah, my own ticket to take the kids, correct? And then I had to pay to bring them back. So that, to me, that's not split cost. But what I'm asking for is to split everything evenly, just to make things easier.
Okay, and I guess I didn't understand your response, but it's okay. All right, now going to your move to Washington. Could you remind me again what the reason for your move to Washington was?
It was in the best interest of the children and myself. I was pregnant at the time as well. We would be better established over there. We had a lot of social support over there too, so.
Okay, so do you have family over there?
Not immediate family, no,
Okay, are you married to your boyfriend?
not currently.
Okay, are you even engaged?
We plan on getting married soon, yes.
Okay, so are you engaged? Yes or no?
I guess, yeah.
Okay, do you
Yes.
have some sort of ring of engagement?
Objection, Your Honor. She's answered the question, Your Honor.
Sustain, let's move on.
Okay. You never told my client that the reason he moved to Washington was because Mike works at Boeing and your plan is for him to take an assignment in San Antonio in March of 2027.
That's true.
Okay. And so,
That doesn't take away from the fact that it's in our best interest, all of ours.
okay,
Mm.
do you have any evidence to show why it's better to live in Washington for the children than here in Laredo?
Well, my children follow me because my children live with me. I have full custody of my children. I have no geographical restrictions. So where I go, my children go.
Objection,
I'm
are not
pregnant.
responsive.
I'm
Sustained.
not
Let
done
me
with
hear
my
the,
answer.
give me one second. I've sustained the objection. So let me hear the question and then you can answer that question unless there's an objection, Mr. Del Rio.
Said, what evidence do you have today that shows your children are better living in Washington than in Laredo?
I have better support there. I'm able to care for them. When I lived in Laredo, their father continuously refused to have them on his visitation days just to make it harder on me. On days he knew that I had to work, he'd say, no, you figure it out. Going to Washington eliminated all those issues. I don't have to deal with any of those problems anymore. Work is easier because I help with the Airbnbs, I clean, I manage them. The children come with me too. There's no need to worry about, oh, who's going to take care of the kids because their dad doesn't want to. So yes, it was in their best interest.
And so you couldn't do all that in Laredo.
No,
But you were doing all that prior to moving to Laredo. You were still caring for the children and they were still with you, correct?
yes,
So the only thing changed is that Mike has a better job up there in Washington.
no, the issues with the childcare and all that, what I mentioned changed.
But
You're
you have
saying
family here in Laredo, right?
everybody
Your
works,
children
people
stay
work.
with your mom and parents, right?
My mom, because she works as well. At the time, she wasn't working.
Yeah, and so all this seems, the houses that you're cleaning are because of your boyfriend.
They're Airbnbs. Mhm.
And they're because of your boyfriend, correct? They're his property, you said?
Yes, they're his properties, yes.
Okay, and so if you separate for whatever reason, who's to say you're gonna still be able to have that job or clean those houses? Have you thought of that?
I mean, in addition to all that, I don't know if you're aware, but Washington has a lot of opportunity.
Hold on.
They have
you thought,
higher,
I asked you, have you thought about it?
actually, no, because I feel secure in my relationship and I feel like that would not happen.
And
No.
how long have you been dating Mike?
Dating about a year
And when did you move to Seattle?
in June. Mhm.
So for March of 2026, June is 3 months away. So after meeting this person for 3 months, you
Mhm.
decided to move with him to another state?
Yes, correct.
You separate your children from their grandparents and from their father within 3 months because of a boyfriend?
Grandparents, they talk to their grandparents all the time, just like they talk to their dad. And again, like I mentioned, I have a whole log of the days he got them, the days he actually took him in his possession, and the days he denied. So if you're saying that I took them away from him wrongfully, I have to show that there's multiple occasions when he would deny taking them. And even when I moved to Washington, he denied taking my daughter. He only took my son. The next visit, he denied taking my daughter, only wanted to take my
Objection,
son.
Honor, she's narrating.
Sustained.
Oh,
Next.
wait. Now, just to clarify, you did have possession of the children during the 2025, 2026 New Year holiday, is that?
Correct.
Okay.
Yes.
And one moment. Now, do you plan to return to Texas at some point with Mike?
At some point, yes, that would be our goal.
Do you have a best case scenario? Everything goes well for Mike. When would you plan on return to Texas?
It's not just for Mike, it's for all of us, but the return to Texas would hopefully be next year, early next year,
And what city would you be moving to in Texas?
San Antonio. I've made Mr. Maldonado aware of all this.
Now,
I've always update him on the
assuming
plans.
that you do move back to
Mhm.
Texas and live in San Antonio, would you be willing to meet and do an exchange halfway in between San Antonio and Laredo?
Your Honor, I have to object. He keeps on trying to negotiate with my client directly, and I don't think that that's proper questioning.
Sustained. Next question or rephrase.
Yes, I would agree. Well, I mean, I could just flat out, if you're living in San Antonio and my client's living in Laredo, would you agree on meeting at a halfway spot?
Again, Your Honor, same objection. He's trying to negotiate with my client directly. He's trying to go around me and talk to my client directly.
As phrased, agreed, sustained. Next question or rephrase.
I'll move on, Judge. And only one of your children is enrolled in daycare, is that correct?
It's preschool.
Or preschool?
Yes.
And how much do you make monthly?
It varies. I would say around $2,000 a month.
And do you have any expenses for living?
For living, yes. Well, I mean, I guess not anymore. Not young.
And you do receive child support from my client, correct?
Mm-hmm.
How far away?
Yes or no?
Yes, I receive child support. As far as do I have
The reason I say
expenses?
is because aren't going to be taken down in the record. It has to say yes or no. So you did.
sorry.
Next question.
Yes.
How far away is if you know, and you may not, it's okay. How far away is Seattle? What city do you live in again? I apologize.
Des Moines.
Okay, how far away is Des Moines from Seattle?
I would say maybe 30 minutes, 25 minutes, depending on traffic too. That would increase a lot, but it depends. I'm not too sure.
Okay.
Are you talking about the airport?
Yeah.
The airport's around 15 minutes away.
50?
15.
15,
15.
okay.
Yeah, it's not far.
Okay, that's pretty close.
Mhm.
But I'll pass the witness, Judge.
Just to follow up very quickly. So then you said you gross around $2,000 a month. Is that correct?
I would say on average, I think so.
Okay. And so that's roughly about $24,000 a year gross. Is that accurate?
Yes.
And now that you're with your boyfriend,
Mhm.
he pays most of the expenses for you. Is that correct?
Yes.
Okay, understood. Pass the witness. I don't have any further questions.
Anything else, Mr. Del Rio?
No, Your Honor.
Mr. Gonzalez, before I release this witness, I need to apologize to you. Let me give you a chance to ask any questions for Ms. Hernandez, and I'll give you the same opportunity for Mr. Maldonado. Mr. Gonzalez.
Yes, Your Honor. The only questions that I would ask is if also to take into consideration the unaccompanied minor fees in case one of them doesn't travel one another, and I'm just happy to do the math. But that's pretty much it, Your Honor, for on my end.
The unaccompanied minor fees, what gets taken into account for child support purposes?
Just if whenever they decide, Your Honor, what the actual cost is, how the actual cost is going to be split. Just in case one of them can't travel one another. That way I can just make sure to make note on mine.
Mr. Del Rio and Mr. Peña can correct the court, but that won't be an issue in this case because the youngest child is 2, and by testimony of Ms. Hernandez, there's likely to be a change in living circumstance in 2027 before the youngest turns 5. So that won't even play into any consideration for these persons.
That would be my understanding.
Yeah, I mean, hypothetical till it happens, but nobody here is going to argue that it's likely to happen. Any question? Okay, so to confirm, Mr. Gonzalez, any other questions for Ms. Hernandez?
No questions, Your Honor.
Ms. Hernandez, you may step down. Any questions for Mr. Maldonado, Mr. Gonzalez?
No questions, Your Honor.
Any other witnesses, Mr. Peña?
No, Your Honor. I mean, I got some brief argument, that's all.
Very brief. We'll begin with Mr. Del Rio. Closing.
Judge, the two main factors to consider here are frequency and continued contact, as is what is strongly encouraged in Texas family courts. The struggle here is my client's financial ability to incur an additional cost because of mother's, Ms. Hernandez's decision to move out of state. She bore the cost, and traditionally the person that creates the distance should have a disproportionate share or bear the larger share of that cost, Your Honor. I think also the consideration of the timing of the move and the reasoning behind it, although she denies it, I think it's patently clear that it was to benefit her boyfriend in the hopes that perhaps the relationship continues and he gets a better job and she can make more money, which theoretically could benefit her children. That is all speculative, and it's not the fact of the reality today. It's almost akin to her doing something to improve separate property of this man, and the community estate and the children, her children, will get no benefit. Now, with regards to the expenses, you heard my client's limited income, Judge, and you heard the expenses. And so we are asking that Ms. Hernandez does pay for the flights of the children for my client to have them during his standard monthly visits. And my client would agree to pay for the children so that the children come down for the extended periods of time. We are asking for extended summer to allow that lost time if, for example, Your Honor chooses to oscillate the calendar months, so to save parties expense. Or, Your Honor, we are asking to take into account all the numbers and propose a discount in child support to offset the expense that my client would have. We are specifically asking, Your Honor, that my client does, for just the year of 2026 and going into 2027, get all of Christmas, because he would be entitled to that under the standard order, as well as the New Year's, and that is because he missed out on that this past time. So we would ask for that to be sort of a makeup period. And Your Honor, we would ask also that that if mother is unable to fly and it causes the missing of some dates, that my client would get to make up that lost time. I know it's medically sound for her to avoid flying within that late trimester, but we would ask perhaps that the children get to stay with father until the child is born, and mother can continue to travel with them, Judge. And again, we believe this is more of an equitable argument. I think this sets a tone that is very dangerous if it's not addressed against the parent that moves. I think they would be arguing the same thing if, for perhaps if my client moved to Germany, they'd probably wouldn't be happy splitting the bill on that flight for the children, or even want to keep up the frequency. And so that's why I think traditionally courts throughout Texas will disproportionately have the parent that creates the distance, especially to a degree at this level, in favor of the party that has moved, Your Honor. That is all.
Closing, Mr. Pena.
I'm not really sure how logistically we could achieve what Mr. Del Rio is suggesting. It sounds good when he's saying it, but when we try to do it in real life, I think we're going to encounter some problems, like the one Your Honor described earlier with, well, what if I want a first-class ticket since you're paying the bill? The other thing, you know, all my client did was fall in love and follow her heart and decide to start a family in a different place. She's done nothing wrong. There was no court order. There was no geographical restriction. And it seems like this gentleman, it just seems like he's jealous and kind of petty about this. I think that the reasonable thing to do is to pay half the expenses. They keep on wanting to paint her as having, abandoned Laredo or anything, but she has the right to go anywhere she wants and start a family with whomever she wants. And so I would ask the court to take that into consideration. She understands she moved. And so, I don't have I don't have really a good argument to stray away from standard visitation, frankly. I know that there may be costs associated with that are going to be difficult to bear. And that's why I think both parties suggested an alternating schedule. But other than that, I'm going to leave this to the wisdom of the court, Your Honor.
Closing, if you so choose, Mr. Gonzalez.
I'm good, Your Honor. Thank you.
What request, if any, would the Attorney General's office make at this juncture?
No request, Your Honor. We usually ask to follow the standard possession order in general, but this is a special case, so we would just leave it to your decision.
Mr. Maldonado and Ms. Hernandez, you present a very interesting and unique set of circumstances. I've had cases, actually in Washington too, I believe, where one person moved, but your set of circumstances is very, very unique. Went into this, I thought, and I was trying to get your lawyers to get to a place where they would agree to at least oscillate, because it sounds like that could have been some of the things that you were at least talking about, and you didn't get there. Now that I've heard from both Mr. Maldonado and Ms. Hernandez, I have actually reached a different conclusion, which is surprising to me. And I think I know what is in the best interest of your children, and this is what I think it is. So as to the move, there is no information in the record to permit the court to make a finding that the move wasn't in their best interest, which means, all that to say, if you can't prove it, it is not disproven. So case law says, as the court noted before we started, that if one parent, mom in this case, moves and has a better quality of life, which is what she testified here, then by extension and almost by osmosis, the kids should be doing better. Not that they are, but they should. And certainly there's no evidence to the contrary in this case. So the court makes no finding that the move wasn't good or good initially or good now. The question is how best to facilitate what the policy of the state of Texas is, and that's how to make sure that both persons, both mom and dad, have a close and continuing relationship with each other. I thought the court was going to order that mom pays the full set of flights one way and dad pays a full set of flights one way, because that would at least give one person the responsibility without having to go and charge the other person and have to hound them for 50% of the bill or whatever. I'm going to reach a different conclusion, because if it is in their best interest to move, It's 2026. I think it's also in their best interest to travel. Travel for kids opens up a world of possibilities. For those of us that are like Mr. Del Rio's age or Mr. Peña's age or my age, travel really didn't exist the way it does now, but travel opens up culture, culinary experiences, and quite frankly, reduces the fear for young persons as they get older, but also expands their horizons so that when they're adults, they're much better rounded persons. Because of that, the court is going to reduce child support to $660 per month, beginning April 1st and running through March 2027, conditioned on Ms. Hernandez moving back to Texas. If she stays, if she doesn't move to San Antonio, child support stays the same. If she moves back, then it reverts back to this $1,060. Because child support is reduced, Mr. Maldonado is completely in charge of travel. Knowing that travel should not be looked at as a burden for Mr. Maldonado, but the time spent with children en route, I guess, to San Antonio, if that's what he chooses, could be good quality time. And the time spent in the flights with him is also good quality time. If done well, then it is in their best interest. And that's the finding that the court makes, that this would be in their best interest. I'm not going to make any decisions on an accompanying minor. I think that would be appropriate for the court in about 2 to 3 years. Just trying to think if there's anything else that I need to rule on. Mr. Maldonado will have the election of 3 or 4 days so that he can find the best flights he should take into consideration, but doesn't have to strictly follow a school schedule. He can use any airport, so pickup and drop-offs would be at the Washington airport, so long as they are no later than 10 p.m. So he gets to choose the pickup time, and the drop-off time is no later than 10 p.m. as the posted flight. So he can choose a 10 p.m., but if there's a delay, that's not on him. He will have extended summer for a minimum of 42 days, and he will have a week during Christmas days at his election for flights and all these things. Mr. Del Rio, is there any portion that the court did not address?
I just need some clarification on that Mr. Maldonado is completely in charge of travel. I don't.
Inaudible.
Could you clarify, Your Honor, with regards to the order language of Mr. Maldonado was completely in charge of travel?
He books his flights, and the court has given him some breathing room to make those purchases. He doesn't have to ask. He doesn't have to ask or get permission from Ms. Hernandez. He just books his days as long as he gives at least 45 to 60 days. And he's going to want to ostensibly make those purchases in that window anyways. But as soon as he makes those purchases, he's to notify, not ask permission, just notify Ms. Hernandez of when those are. But he's completely in charge of booking those flights.
To fly to visit the children?
Or to bring them back.
Okay.
Or visit wherever he wants.
And so if he is to book the flights to bring them down,
Um,
how would the children get down here to Laredo?
he would bring him back.
So he'd have to fly with them. Fly
Yes.
up and then fly them back. Okay.
That's right.
Okay. And if he were to book the flights to somewhere else, he'd have to fly up there, get him, and then fly him somewhere else. Is that what you're saying? Because you said you don't have to fly him to Seattle, you just fly him somewhere else.
I don't think I said that.
Oh, okay. I misunderstood you then, Judge.
I mean, I guess he could, but that's not what that's not
Okay.
what am I missing? I think I've covered everything.
Your Honor, one clarification. You said father has a week during Christmas, and I just want to know what that means exactly, so I can write it down.
So he's going to look ostensibly for the best flights at his disposition, and he's going to choose a 7-day window that December 25th falls within that window.
So he's going to get every Christmas, is that correct?
No, he's going to get this Christmas. And remember, what the court heard in evidence and testimony was that mom was supposed to have Christmas and he was supposed to have New Year's. So I'm just reiterating the oscillation of holidays.
So then all other holidays are
Standard.
Standard, okay.
So Christmas does alternate, is that correct? But it's a week. He has a week on his Christmases. He has a week that he can choose.
Yes.
Understood, Your Honor. Thank you.
And so if he has New Year's in even years, he would also get that.
Yes, just like standard. I'm just confirming that we're continuing on the oscillating schedule.
As far as the standard, Judge,
I believe I have New Year's on even years. So it would be my New Year's.
Okay.
Right, because it's his Christmas this year, and then it missed.
But I think they're asking for both.
Well, that's what we asked for, Judge, to make up for the fact that he missed out on his Christmas.
I'm fully aware.
I know. Okay. As far as then for Father's Day, I guess then if he wants to exercise his Father's Day, that's because it's not going to be.
So remember, he can choose any dates that he wants, up to 4 days, so it can be an extended weekend. Okay. But he should give at least 45 to 60 days. But he's going to want to do that anyway. He's the one that's going to be in complete control of travel. All he has to do is just give notice. Okay. I'm picking them up at the airport. In other words, and remember, for example, if the flight leaves at 3, that doesn't mean show up at 3. That means have the kids there at least 2.5 hours before. You're flying out of Seattle, and Seattle has that flown in, the boomerang, and you're going to want to get there at least 3 hours before. Their terminals are not very straightforward.
I don't have anything further, Your Honor.
Mr. Del Rio, thoughts, comments, questions, or objections? I hope I've covered everything. I hope I've considered everything. And there may be stuff that I'm missing, but if I am, you can always come back and tell the court that I missed something. I'm just trying to give these children the best resolution and what's in their best interest based on what the court heard here today.
I don't have anything, Your Honor. I guess if there's anything, no, I don't see anything at the moment, Judge. I guess if there's anything else, we can file an advisory at the court.
I tell you what, just reduce child support.
Yeah.
Because it shouldn't be conditional, because it's a what if until it actually happens. So we have to presume that Ms. Hernandez is going to be in Washington indefinitely until she moves, and then you come back and ask for a modification. You come back and you say, I need more child support because now I live in San Antonio.
So there is no auto step up then, is that correct?
No, because now that I think about it, she may move earlier or she may never move until it's proven to the court. The court shouldn't make things conditional on somebody else's actions. It should be proven in court.
That's fine, Your Honor. We understand.
Move it to $600 per month until further orders of the court. And if there's a change in circumstance at any time, You're welcome to come back. Mr. Del Rio, anything else on this case?
No, Your Honor.
Mr. Peña, anything else on this case?
No, Your Honor. Thank you for helping us resolve this, Your Honor. It was a complicated, unique situation, and it's a pleasure to
Agree
work
with-
with all of you.
I agree with that. Mr. Hernandez, do you have any questions for the court?
No, no, Your Honor.
Mr. Maldonado, do you have any questions?
Inaudible.
Turn your microphone on, please.
All right, sorry. I don't have any questions. I just wanted to throw out that, getting days off from work, it's not guaranteed, and it's not as easy as my days off not consistent. They switch every
So-
other shift change, which is every 2 months.
Well, I tell you what, in fairness, not so much to you, Mr. Maldonado, but in fairness to your children, this order is an order of a Webb County court. So if there's ever an issue, you can ask your lawyer to draft up some proposed language that this court can send to your employer. If Mr. Peña does not have any objection to that language, I will sign off on a letter asking your employer, not as a favor to this court, but as a benefit to your children, to give you some flexibility. And I can't believe that anybody would object, because that would be in your children's best interest. Thoughts or objections to that, Mr. Peña?
Well, I'd be happy to consider it, Your Honor, and show it to my client, and it seems reasonable, Your Honor. I haven't really thought out about all the possible unintended consequences, but it seems reasonable.
So what the court is saying, let me flesh it out. As a judge in this county, knowing that one of the parties works for law enforcement, enforcing of its court orders, and the flexibility to work under those orders, I would presume that Mr. Maldonado's employer would agree to be flexible without knowing anything else. Could be wrong.
I would have no problem supporting that request, Your Honor.
Right, so you have this court support, Mr. Maldonado, not for your benefit, but certainly for the benefit of your children. All right. Mr. Peña, Mr. Del Rio. Oh, these are the orders of the court. The orders are due to the court honor before.
April 27th at noon by submission.
All right. Mr. Maldonado, Ms. Hernandez, I wish you both well. More importantly, I wish your two children all the best. Good luck to all.
Thank you. April 27th at noon, you said?
By submission.
By submission. Thank you, Your Honor. That's all I have.
Have a good day. It's good to see you both.
Thank you, Judge.
Yes, the court will stand at ease before proceeding to the next hearing. We'll stand at ease momentarily.
All right. We're ready.
Good afternoon. This leaves one case on the court's docket. Court is back in session. This is the case on page 2. Case 3, Maria Elida Moreno versus Antonio Alatorre III, cause number 2012 CVW 2193C3. Court marks attorney Juan Jose Garcia present by video conference. Mr. Raul Gonzalez also present by video conference. He is the lawyer from the Attorney General's office. Ms. Moreno is present in person. She is self-represented, and Mr. Alatorre is present in person. Mr. Garcia, this is your petition?
Yes, Your Honor.
What is it that your client is requesting?
My client is requesting that Ms. Moreno have visitations in accordance with the Texas Standard Possession Order, Your Honor.
Which is, how does the standard possession order apply in their situation?
Well, right now they only have every first, third, and fifth from Friday, I think at 6 to Saturday at 8. So it would expand and give her more time than what she has under the temporary orders.
Do the parties live within 150 miles apart?
No, Your Honor, I think they live more. I think she lives in Houston and he lives in Austin.
Right. So you think that by them living in two different cities, San Antonio and Houston, that she's entitled to more than first, third, and fifth?
No, just that, Your Honor, just the first, third, and fifth weekends. The standard.
Mr. Gonzalez, what is standard for persons, parents that reside more than 150 miles apart?
Mr. Honor, let me pull it up. Give me 1 second. So in summary, it's either going to be the regular first, third, and fifth weekends or 1 weekend per month. That's based off the possessory conservator's choice. With 14 days of written or telephonic notice that they're going to be traveling.
Right. So although you're requesting standard, Mr. Garcia, standard, the way it applies to these persons, if everything pans out, is that Ms. Moreno would have the election of 1 weekend per month, not more than first, third, and fifth. Knowing that, what is Mr. Alatorre's request?
I would have to ask Mr. Alatorre, Your Honor, because he would just told me that he was fine giving her the first, third, and fifth weekends.
Yeah, I'm fine with that.
But Ms. Moreno, you don't agree with that, do you, or do you?
No, Your Honor, before I had the first, third, fifth weekend and summers rotating, we're changing in the holidays too. Mother's Day and all that, but not even right now. I get to go pick him up on my weekends all the time.
You do or you do not?
Not all the time.
Why is that?
We did have he has some issues, I had some issues, but there's one weekend that he had an issue with his vehicle. I offered to come pick up Antonio and drop him off because I was able. I had a running vehicle at the time, and he declined that. There's other times that we have problems with each one of us.
When you say problems, are you talking about transportation issues?
Yes, Your Honor. There was.
Let me ask Ms. Moreno, are you, because it's your statement, do you mean that there's transportation issues? Or what are those problems?
In my case, the first one of the months I had to I have other children that their dad lives in Mexico, right across the border. So I do travel for his visitations. And also I have my family here. So in one case, my mom, she had an emergency in the hospital. Vehicles problems, no, because if my vehicle runs down, I have the opportunity to rent through Turo.
Okay, so the court is incorrect. It's not, the court misunderstood. So it's not a transportation issue. What are the problems that you and Mr. Alatorre faced to do the visits? Give me an example.
It's because, Judge, when we had the standard visitation, Mr. Alatorre would tell me that he never told me like in person, like, hey, you know what, this is going on with the kids. I don't want Antonio to come. He just said, no, you're not seeing Antonio because I feel for his safety. Stop harassing me and stop calling. He don't want to talk to you. He did this and that. But I always attempted to visit. He would decline my visits. I moved, he moved, but there was never communication. Like,
Well, let me ask you this, because now you heard, I know you heard what Mr. Garcia said, that Mr. La Torre wants to give you first, third, and fifth, but the court asked Mr. Gonzalez, who's here on behalf of the Attorney General's office, he confirmed that because you and Mr. La Torre live more than 150 miles apart, that you, Ms. Moreno, can elect any weekend you want,
oh,
1 week in a month. What do you think about that?
I would rather have more time to see Antonio. I'm available to go pick him up and drop him off if necessary on the first, third, and fifth.
But that's what Mr. La Torre is requesting. So it sounds like you both of you are in agreement.
We already had that, Judge, but then he did a restraining order, and then he wanted supervised visits, and then he wanted that we couldn't come in agreement on.
Are you making that request here today, Mr. Garcia?
No, Your Honor.
Right. So you don't have to worry about restraining orders or supervised visits. It sounds like you can both agree to first, third, and fifth. Is that what you're requesting today, Mr. La Torre?
Yes, Your Honor.
Is that something you're agreeing with, Ms. Moreno?
I wasn't in agreement because I wanted to get sole custody of Antonio, so he can come visit him, because his problems are mainly vehicle problems. The times that he hasn't been able to pick him up is because he has problems with his vehicle.
Well, let me tell you this without knowing anything else. So in general, I haven't heard any evidence and testimony, right? So I can't make a decision yet, but in general, without knowing anything else, if this were a standard normal case, and they never are, right? Because there's all these specific things that makes your situation very special and unique. But in general, without knowing anything, all things being equal, normally the best thing that I can order is that pickup are in the city where the child resides, and then the other person picks up in the city where the child is. Because if I do anything different, if this court orders anything different, somebody's going to be halfway in between, waiting while somebody is stopped to go to the restroom, had a flat tire, there's traffic, and this way, the sooner you get into that city, it's on you, right? So without knowing anything else, just know that this court is, unless you present some good, compelling evidence to the contrary, it's possible, maybe even likely, that I'm going to order, if this child continues to reside with Mr. La Torre, that Ms. Moreno pick the child up where Mr. La Torre resides, but then Mr. La Torre has to go and pick him up where Ms. Moreno resides. Because then it's on you. If there's traffic, that's your situation. If you run out of gas or have a flat tire or have to go to the restroom 5 times between the 2 cities that you live, that's on you. That's not on the person that's there waiting. I just don't like to hear when moms and dad tells me that they're at a gas station waiting while the other person had a late start and a delayed driving time and then got a flat, and the other person's just there waiting. Well, so knowing that that's a good possible outcome, Ms. Moreno, what are your thoughts?
I would agree to the first and third and fifth weekend. I can pick him up and he can pick him up at my residence.
What do you think about that, Mr. La Torre?
Well, I wanted to see if we could keep the meeting where we met to pick him up in Plantonia, which is, I don't know how far is it from her. For me, it's an hour and 20 minutes. We've been doing good. The time that she said I have vehicle problems is because one time she was sick, she couldn't drive. She asked me I go pick him up. I said, okay, I had no problem. That weekend where she had I had car problems, I didn't feel comfortable not having a working vehicle in case anything happened that I had to go pick him up. That's the reason why I declined, because I didn't want something happening, you know what I mean? Hey, I can't think, can you pick him up? And me not having a working vehicle, that was the only issue. But
I think that's a court point. That's court's point. If you have an issue with a vehicle, even if Ms. Moreno agrees, now she has to make the entire drive for a problem that was associated with your vehicle.
Yes.
But the shoe could go on the other foot. If Ms. Moreno has transportation issues and you agree, then you have to do double the driving for something that is her responsibility. But if the court says visitation begins when you arrive at the other person's residence, you have an incentive. You have incentive to leave early, to not take extra time, to take the most economic route, to not take extra time with bathroom breaks and all these things. Plus, if I order you to meet halfway, there's a 80% chance. I've done this long enough to know there's an 80% chance there's going to be 1 or 2 weekends a month. You're going to sit there and wait 20 minutes if you're lucky, 2 hours if you're not. And I can't, you can't, and Miss Moreno can't prevent accidents. You can come back and argue, and you're going to say, well, I got rear-ended by an 18-wheeler, and by the time they took the report, and it wasn't a big deal, but then I was waiting, and judge, he made me wait. I can't do much with that. So if I put the burden on you, visitation begins when you arrive. You have an incentive to get there. If your car breaks down, you have an incentive to fix it. But same thing for Miss Moreno. She has an incentive to get there, to begin possession. And she also has an incentive to fix whatever transportation issues she could have. Ms. Moreno, what are your thoughts?
Yes, Your Honor. So the half meet spot at Plantonia doesn't really work because I'm usually like 5 minutes late. There's construction going on I-10 to get there. We are kind of late. Sometimes I'm even 20 minutes late. He does work with me. We do work together, but I do also have other children.
If it was 5 or 20 minutes, I wouldn't even sweat it. But with transportation,
I'm fine with
I
that,
hear.
Your Honor.
Oh, there it is.
I'm fine with that. Like every time, like if she's a little bit late, I have no problems in waiting. It's Friday. I don't have anything until Saturday. So, you know what I mean? Like if she tells me, sometimes we've been having better communication. So she'll be telling me like, hey, I'm running 5 minutes late. I'm like, that's fine. You know what I mean? I got nowhere to be. You know what I mean? As soon as she picked them up, I go home, rest.
Are you telling me, Mr. Latorre, you don't have a problem halfway?
No.
And you're telling the court the same thing, Ms. Moreno, you don't have a problem halfway?
I do have a problem
You
halfway.
do have a
I
problem.
prefer to go pick him up at his residence in San Antonio or Austin. I believe he's a self-contractor, Your Honor, so he does have to travel for work and all that stuff on Fridays or something. And I prefer to pick him up wherever he resides, and then he can pick him up on Sundays.
Well, it sounds like, Ms. Moreno and Mr. Latorre, you have an agreement about first and third and fifth weekends.
Yes.
The only question is pickup and drop-offs. Is that your understanding, Mr. Latorre?
Yes, well, I'm fine with what she's saying. I was just saying if she wanted just to halfway, that way she didn't have to drive all the way. But if she wants to do that, I'm fine with that.
Is that your agreement, Ms. Moreno?
Yes. I also have another petition, Your Honor.
What is that?
So in our parents' orders, like in this TRO is like the other parents not supposed to talk in front of our children bad about the stuff, and communication between parents is with parents, not children. Pickup drop-offs is communication with both of us, not our son. Also, like whenever he moves, if he can communicate it with me, because I always try to find him and he refuses to give me the information where our son goes to school, his health information, he just got glasses, I believe, a month ago. I've been asking for a whole year. When I call the school, they can never give me any information because the court orders, like the papers, they're not documented, and I'm not documented as his emergency contact or his like anything. It just appears as mother, my name, and that's it. No contact information. And my son also, he has a device, a cell phone. I don't know if it's connected or not, but Mr. Latorre had agreed to give me like direct contact with my son. He is 13, Your Honor. He's gonna be 14 in April. And the only thing I want is communication fully with my son. So I can be able to say happy birthday. If anything's running out, let him know that we're gonna pick him up, and especially with his brothers. He has 4 older brothers that he likes to talk to, but as far as what he says is like that doesn't allow him to do all that communication.
What, if anything, would you like the court to do and know, Mr. Latorre?
Well, like I said, we've been having better communication now, and I'm fine with anything. You know what I mean? Like I said before, we did have some issues, but right now we've been having a good communication. I would like to keep it that way from now going forward. So,
Is there any child support being paid one way or the other?
no, Your Honor.
I pay medical from Antonio.
And are you good with that arrangement, Ms. Moreno?
Yes, because
Are you good with that arrangement,
Yes, Your
Mr.
Honor.
Latorre? Mr. Alatorre?
Yes, Your Honor.
Do you believe that this arrangement is in your son's best interest, Ms. Moreno?
For now, yes, Your Honor.
Do you believe that this arrangement is in your son's best interest, Mr. Alatorre?
Yes, Your Honor.
So let me do this. Let me confirm your agreement, fill in some blanks for you, and then I'll give you some time to tell me what you think and object if you want, and we'll take it from there. Ms. Moreno, Ms. Relatora, in your case, cause number 2012 CVW 2193C3, the court finds that it has continuing exclusive jurisdiction over this matter. The issue before the court is on possession, visitation, and access to your 13-year-old son. The court finds that you have an agreement and you believe that this agreement is in your son's best interest, that Ms. Moreno exercise possession and access to your son the first, third, and fifth weekends of the month. Pickup will be at the other parent's residence. So Ms. Moreno will pick up this child at Mr. Latorre's residence, and Mr. Latorre will pick up the child then at Ms. Moreno's residence. The court will order a permanent injunction, which means that neither one of you can speak ill about the other person, certainly not in front of the child. You're supposed to help him and foster a good, close, and loving continuing relationship with not only yourself, but with the other person, with the other parent as well. Regarding school, Mr. Alatorre shall inform Ms. Moreno within 24 hours if the child ever changes school. He is to share, and he is to add her name to the school records so that she can access that information freely. She can't make changes to it, but she can access the information. In that regard, Mr. Alatorre, you're to share any usernames and passwords regarding parental electronic notices or systems for whatever school your son is enrolled in. You are to provide Ms. Moreno with healthcare information within 48 hours. So any doctor's visits, appointments, you need to let her know within 48 hours of any results of tests, visits, consultations. That's different from medications or emergency medical treatment. If there's any emergencies, you need to let her know as soon as reasonably possible, no more than 6 hours. So if you get to an emergency room, you should notify as soon as possible. But I'm going to make a finding that no more than 6 hours is reasonable, no matter what's going on. Your thoughts, comments, questions, or objections, Mr. Alatorre?
No, Your Honor.
Same question, Ms. Moreno. Any thoughts, comments, or objections?
For the schools, I did my investigation. He's been moving a lot schools, and he's already in middle school. So if he can please, like, I don't know his situation, just be stable, because it affects Antonio, because he's been moving schools a lot.
Right. So what the court ordered here is that if there's any change, Mr. Alatorre has to notify you within 24 hours. Now, I'm going to order that you all communicate through app close, so there's a record of it, and you can communicate respectfully with each other. But Mr. Alatorre now has a legal duty by court order to notify Ms. Moreno of any changes, and then Ms. Moreno can come back to court and say, look at this move and this move and this move. This is not good, or that's fine for whatever reasons are presented to the court at that time. I'm also going to order, Ms. Moreno, that you have, excuse me, daily electronic access to your son. I presume that sometime between 7 p.m. and 8 p.m. would be good. It can be as short as 2 minutes or as long as an hour, whatever you and your son feel comfortable with. But it sounds like it would be good that you have daily electronic communication, not only with you, but with his siblings as well. Thoughts, comments, or objections, Ms. Moreno?
No.
Mr. Garcia, thoughts, comments, objections?
No, Your Honor.
Mr. Gonzalez?
No, Your Honor.
All right, the court finds that all of these things are agreed to, and the things that weren't, that the court filled in, the court finds that all of this is in the best interest of the son. By the way, the court had a very nice and pleasant conversation with your son. So I know exactly who he is, how he's doing, where he lives, what his thoughts are, his personality and his character. And I think he's in a good place, and he's going to be even better after this. The court does this in his best interest. These are the orders of the court, and the orders are due to the court honor before
April 27th at noon by submission.
Do you have any questions for the court, Ms. Moreno?
No.
Do you have any questions for the court, Ms. Torre?
No, Your Honor.
Anything else, Mr. Gonzalez?
No, Your Honor.
Mr. Garcia?
Oh, Your Honor, I'm sorry, just to clarify, on the daily electronic access is for the party not in possession, Your Honor?
Yes. Sometime between 7 and 8.
All right, thank you, Your Honor.
All right, Mr. Gonzalez, Mr. Garcia, good to see you both. You're excused. Ms. Moreno, Mr. La Torre, I wish you both and your son all the best. Good luck to all.
Thank you.
Ms. Flores,
you.
have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
That now concludes this docket held in person and by video conference for Tuesday, March 31st, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. I wish you all well. Have a good night.
Thank you, Your Honor.